Добрий ранок, Pan Valery. Welcome to this interview for the position of the disciplinary inspector. So first of all, let me introduce the commission. I am Reda Molene, the chair of the commission, and we have Yulia Bokova, Olena Kovbi, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Would you have any requests regarding the composition of the commission? Дякую.
Немає ніяких запитів, нічого.
Дякую.
No.
So the interview will last for about 1 hour. We will be asking you some questions about your professional background, experience, your insights about judicial ethics and integrity. And at the end of the interview, you will have several minutes for your final comment. Also, I would like to inform you that the interview is broadcasted, and if there is any information which falls under restrictions for its public disclosure according to the martial law, please inform the Commission accordingly. Any comments, requests so far?
Ні, на даному етапі немає.
Not at the moment, thank you.
So we could then start the interview with your introduction and presentation of your background and your vision of this service and the role of disciplinary inspectors and your motivation. So you have up to 10 minutes for it. Thank you.
Дякую. Добрий день всім, добрий день.
Good morning, everyone, all the commissioners. I want to start with my background. I started working when I was in the 5th year of my university. I started with a legal company, law firm, dealing with bankruptcies and civil cases. Then I started to work with LLC. I was an in-house lawyer. Then I started doing entrepreneurial activities. I received a license to practice law as an attorney in 2021. I got a job with the Supreme Court as an assistant to a judge. And I've been working there since then for about 3 years. Now this is a cassation economic court, but since 2023 it's a grand chamber of the Supreme Court. As to my vision, my understanding of the SDI, I believe this is an extremely important service because since my studies and since I've been working, I've been witnessing the judicial reform in Ukraine, and I think we need to really complete it and to have the sustainable rule of law in Ukraine. And purification of the judiciary is a very important element of it, and it can happen with a disciplinary procedure. In particular, the SDI is supposed to make sure that when the HCJ and disciplinary chamber consider disciplinary cases, they act as a quasi-court, but it shouldn't be the case. The HCJ shouldn't be the investigator and prosecutor and the court. I think the SDI should kind of help to distribute the functions of the disciplinary inspector. Will be the investigator, will investigate into the circumstances of the cases, attend the sessions of the disciplinary chambers so that or the HCJ sessions, and present opinions to the HCJ and the chambers. And the disciplinary inspector is not only a technical worker who only makes an opinion. He must attend the sessions, defend his opinion, and provide arguments supporting his opinion. And as a member of the disciplinary proceedings, he can provide evidence, ask questions to the witnesses and parties to the proceedings. So the role of the inspector in the proceedings is hugely important, and this service, in my view, will strengthen the independence of the judiciary and help to purify it and make sure that the disciplinary proceedings would meet the standards of the EU and the European Court of Human Rights. Thank you.
To Commission member Olena Kovbi to start this session of questions with regard to your professional background and competence. Thank you.
Вітаю вас, пане Валерію.
Good morning. At this stage, Valery, you have taken some tests, and it was quite a journey for you. So let's start with answers and questions. You've been an assistant to a judge in the Supreme Court. Please tell us, do you come across cases in your work when you prepare a draft, an opinion, and a judge doesn't agree with you? What do you do? Can you defend your position? And what do you do in this case if you are appointed to the position of a disciplinary inspector if the management of the service doesn't agree with your opinion? Yes, these situations do happen quite often. My friends, my relatives always say that I have always my own opinion about everything. So yes, my position may be different from the position of a judge, but I try to defend it. I try to provide argument to defend it. Just recently there was a case whether to accept a case or not, and most of the people, because this is a grand chamber, we can either accept it or return it to the cassation court, but most of the people wanted not to accept it, but to defend my argument I took the similar cases, the comment to the civil code and so on. If this case happens while I'm working at the service, I think I will defend my position as well, but that would be different from what I've got right now in the court. Because I'm an assistant, I can share my opinion, but it is the judge who has the final word. He may agree with my points or not, and I cannot influence that because we have independence of judges. But in the SDI, the inspector is independent. He prepares his opinion. He is not dependent on the head of the service, and he prepares the opinion based on his understandings, on his position on the law, and then he submits the opinion to the session of the ATJ and defends this opinion. Okay, thank you. In your view, the main objective of the establishment of this service, what is it? Do we really need to establish the SDI, and if yes, why? Because today this function is being performed by the ATJ. So in your view, why? As I said, it is done to distribute the functions that are not inherent for the ATJ, to avoid the ATJ being at the same time the investigator and the kind of quasi-court. I think we really need to do it because this is going to ensure the independence of the investigator. Right now we have a situation when a rapporteur, a member of the ATJ, and he also kind of investigates into disciplinary cases. He attends the session, and there might be he may have already some opinion on the case, not a bias, but some sort of an opinion. But with the SDI, there will be a person who investigated on the case, provided the argument to the chambers, and the chambers, when they look at his arguments, they already make the decision. Thank you. Based on your resume, and you now confirmed that in 2021 you received the license to practice law as an attorney. Is it correct that you suspended it on 2023? Yes, in June. So you... Oh, I terminated it. Yes, I terminated the license on the 5th of December 2023. Please explain why did you decide to terminate the provision of services as an attorney? Well, I'm an assistant to a judge. There is a decision of the Council of Judges of Ukraine dated back to May 2023 that an assistant to a judge cannot be an attorney. I disagree with the decision, but there was a decision I had to obey. And I was bound with the rules of ethics of a defense lawyer. So I already had some cases in the pipeline. When I brought them to the end, I decided to terminate the license to respect the decision of the Council of Judges. Well, thank you. In the Supreme Court, in the Grand Chambers, we know there are a lot of cases of how could you combine the practicing law as a defense lawyer and being an assistant to a judge, and at the same time you were also a director of a company. Well, I was director of the company until October 2021. 3rd of January 2022. That's yes, maybe that's according to the document, but that was decision of the founder. But I don't know when they brought the decision to the registrar office. So actually, I didn't perform as a director when I became a member of the Supreme Court. We have an e-court system, so anytime you can submit the documents, and you do it easily. You can do it in your free time. You can take part in different processes, and most of the processes were like written proceedings without summoning participants to the court sessions. Okay, what do you think about the situation when a person who works as an assistant to a judge at the same time acts as representative of other people in court cases? Well, there might be a conflict of interest in this case, but I was not taking part in the proceedings considered in the Supreme Court. The situation in Ukraine is that an assistant is a patronage service, so it's not like civil service, and we have a special contract, so there is not conflict of interest. Maybe there was a conflict of interest on ethical grounds, yes, but I tried to make sure that my work there and my work as a defense lawyer wouldn't overlap and not take part in such cases. How did you manage to combine them? Because the courts do not work on weekends. So how did you do it? Were those only written proceedings? What role as a defense lawyer did you perform while being an assistant to a judge? The role of a defense lawyer was like preparing the written documents, submitting them to court. When I took part in court sessions, I took leaves on that time. So I didn't do it during the work hours as an assistant to a judge. And how did I combine that? As I say, you can submit the procedural documents via the electronic system on your free time, or you can print them out and send them by mail, and the mail works until 9 p.m. to even until midnight, some of the departments. So you took part in the court sessions. It wasn't only written proceedings. Most of them were written proceedings, but there were kind of 2 or 3 court sessions that I had to attend. Why do you think so let's say, why in your view the legislator set forth the requirements to the head and deputy head position as a requirements to judge? Why did the legislation happen? Well, as I say, a person who considers cases against judges needs to comply with the similar requirements as to requirements to the judge, because the person who doesn't meet the requirements cannot judge or make an opinions about the people who are supposed to kind of meet the requirements. So I think, yes, these people need to be also comply with the requirements of a judge. The procedure of our competition, clause 8.9, about the ethical norms and demonstration of impeccable behavior in professional life and personal life. No actions that discredit the candidate and can damage his authority during the professional activities and beyond that. In particular, the information about candidate or members of his family that indicate that he supports the aggressive actions of the Russian Federation against Ukraine, cooperation with its representatives, the representatives of the occupying power or its accomplices, in particular in public statements. What is your attitude? How do you understand it? Well, as a citizen of Ukraine and as a judge, we should, of course, never support the Russian aggression against Ukraine and have no contact with occupying power or any representatives of the Russia. When this cooperation starts, in your view? For you, I've never cooperated with the government of Russia and occupying power. I'm not accusing you of that in any way. You mean, when did it start? My cooperation did start. No, not your cooperation, your understanding. When did your understanding start? Well, I think, as I remember, 28th of February 2014, the occupation of our territory started. So I think, yeah, my understanding started at that time. What I want to say is that these questions that I'm asking are not related to you specifically. Now we are talking about your general understanding and your general attitude to certain matters. Next question. In your view, can we see the cooperation with Russia the violation of the criteria of integrity? Yes, I think that this is a violation, but you need to look at the representative of the Russia, whom we mean. If it is just an individual, I don't think it would be. But if you cooperate with the official representatives of Russia and the representative of governmental officials, that would be a violation. So it's an ethical matter for you. You mean cooperate with? Yeah, provide services, cooperate with citizens of Russia who do not belong to the government authorities. Well, I understand what you're driving at. Well, I think we need to look at the particular person, because right now, after the 24th of February, I think that any contacts from Russians, from people from Russia, is something incorrect. But before the 24th of February, maybe yes, there would be some question, but I don't think there would be violation of the legislation of Ukraine. And I think providing services to certain people in Russia is possible if it doesn't violate the interest of Ukraine and doesn't put under danger the territorial integrity of Ukraine, or doesn't damage or affect the citizens of Ukraine or territory of Ukraine. Thank you, colleagues. I'm done with my questions about this block. Please take the floor to ask yours. Good morning. My small question. What's your understanding of the independence of a disciplinary inspector and the SDI? The independence means that while considering cases and making opinions, studying the materials of the case, he is independent of the head and deputy head. The inspector is an independent person when he considers the case. He makes an opinion himself, so he is not supposed to be under any sort of pressure and accept any other opinion that was kind of communicated to him in any way. So he considers the materials independently based on his internal understanding of the legislation, his beliefs. Let's say you prepared your opinion and a member of the disciplinary chamber disagrees with it. Will it affect and does it not conflict with the principle of the independence of disciplinary inspector? Well, when does it happen? If it happens at the session of two disciplinary chambers? No, in general. We're talking about the principle of independence of disciplinary inspector. Is he independent to the extent you believe is necessary? I think he is independent. Because despite the opinion of the ACJ member, the inspector is supposed to prepare his own opinion and present it. He should make the opinion himself, present it and defend it, even a member of the ACJ disagrees. Well, let's say you are an inspector, you submit your opinion, you provide reasons, and the member of the disciplinary chambers who has the right to do it according to the law returns it to you to kind of amend something and says there were some flaws there. Will it affect is it a violation of the independence? I don't think so, because as you say, the member of the SDI has the right to do so, and in this case the SDI acts as a court and it can consider the opinion and say there are flaws in the opinion, please amend it. but the court cannot tell you how to do it. And I think the member of the SDI can say there are some general comments that the opinion needs to be kind of finalized, but not say specifically. So if they say yes, that the opinion needs to be finalized, there are some flaws, it's not a violation.
Добре, дякую вам. Скажіть, будь ласка, при
Thank you.
формуванні справи дисциплінарної,
While
дисциплінарний інспектор
shaping the case, disciplinary case, the disciplinary, while working on the case, an inspector has the right to file requests, and
знаходиться конфіденційно.
there might be a case when confidential information would be sent about the judge, about the parties to proceedings, about the complainant. How are you going to handle this information? Can you disclose it or can you not?
Розпорядження.
How are you going to handle this information? Certainly this information cannot be disclosed. This is confidential information. It will be stored with the files, but it shouldn't be disclosed. If there is a need to consider these materials at the session of the chambers, and the sessions normally broadcast, but you can stop the broadcast and consider that in camera. So certainly the information should not be disclosed.
Please tell me, what if the head of the Service of Disciplinary Inspectors asks you to provide this confidential information? What will you do? As I've said, the inspector is independent, the head does not have these powers, and in this case I would refuse to provide this information. Thank you. I have no other questions about this. Mr. Valery, good morning. Let me ask you about your current activities as the assistant of the judge of the Grand Chamber of the Supreme Court. I'm sure that you know answers to all the questions because the Grand Chamber reviews decisions of the HCJ, in particular with respect to disciplinary sanctions against judges. Can you please tell me which general grounds can you name in order to quash decisions of the High Council of Justice with respect to disciplinary sanctions imposed on judges? Do you mean the ones set out by the legislation or in general? Given that you know about the case law of the Supreme Court, which general grounds can you name? Like, what is the most frequent ground for quashing decisions of the HCJ? The law sets out 4 grounds to quash decisions. The first 3 grounds are not very frequent. For example, not all members have signed, or the 4th ground is ambiguous. That is failure to provide justification and motives by the HCJ, and that is the ground used by the Grand Chamber of the Supreme Court when the Grand Chamber, for example, specified that there were no motives in the decision when the HCJ adopted it. Can you tell us, please, can you say that the case law of the Supreme Court is established in this respect? I would not say that, because there are different issues during study of different decisions, and it can be different. I cannot say that it is very standardized and that everything will be resolved in the same way. Every instance is unique and considered on a case-by-case basis. What should be taken into account while selecting the type of the disciplinary sanction for a judge? What should be taken into account? First of all, the law sets out that with respect to some disciplinary penalties, disciplinary sanctions are imposed. And during decision on the disciplinary sanctions, the circumstances should be taken into account, the characteristics of the judge, activities of the judge, and the principle of proportionality, so that the punishment is proportional to the committed offense. Okay. Let's now talk about this principle of proportionality. While revising decisions of the HCJ, with which the HCJ imposed a disciplinary sanction on the judge, that is lesser than the one set out for this disciplinary offense. Do you know about the position of the Grand Chamber about this? Do they support such decisions of the HCJ? I cannot say that there are instances like that, but I think that if there are grounds for that, then of course this decision of the HCJ can be supported. But I cannot provide examples from the case law of the Grand Chamber. Okay, then let's talk about this issue. I'm sure that you know the answer to this. What is the position of the Grand Chamber, which of course is taken into account by the HCJ with respect to disciplinary and criminal proceeding, if there is any? For example, there is disciplinary proceeding with respect to the judge, but there is also the criminal proceeding. The case law of the Grand Chamber is established. These are two separate processes, but materials collected during the criminal proceeding can be used to bring the judge to disciplinary responsibility, including materials of covert, investigative, and search actions. And the Grand Chamber has reached the conclusion that circumstances established in the criminal proceeding, even in the absence of the verdict, can be used in the disciplinary proceeding as well. The Grand Chamber supports autonomous disciplinary proceeding, so it should be autonomous. Do you know how these cases were considered in the past? I mean, what were the grounds for this conclusion? Did they suspend these provisions in the past or not? I cannot tell you for sure, but I know instances when disciplinary proceedings were suspended until the end of the criminal proceeding consideration. And now the Grand Chamber believes that these are two separate proceedings. Okay, thank you. No other questions from me.
I would like to ask you about this difference between the patronatna služba and public service. These are different according to the law. Do you see any similarities in the status, duties, responsibilities of people belonging to patronatna služba and public servants?
Я вважаю, що
I think that the assistant, while being a member of the patronate service, maybe is a bit unfair because the work is quite difficult and the person works based on the termed labor agreement. This person is not as protected as the civil servant. The similarity exists in work, but there is no similarity in the statutes. For example, the civil servant is more protected, has more rights, but more duties as well. At the same time, the judge's assistant has just the labor agreement, less protection, and I think that in our Ukrainian reality, the judge's assistant is a member of the support service and the assistant does not submit declarations. But if we equate assistants to civil service, I think that assistants of judges should also declare their income, and because they perform very important work in this body that is court.
With you that the importance and responsibilities are very high for the assistant of a judge, and you mentioned that there are less rights, and it's the people who are working in patronatna služba, they are less protected in some respect. But how about duties and duty to comply with the ethics of public service, etc. Do you see any deviation from those duties in comparison with public service?
я вважаю, що у помічника
I believe that the assistant has fewer duties like that because the assistant is not bound by the special legislation. There are some regulations regarding assistants of judges, there are some criteria stipulated there, but they do not have strict duties as civil servants, so they are freer in their activities, so to say.
Follow-up question. Indeed, there are less probably in duties envisaged or established by the law. But would you envisage any situations where, despite the fact that no duties established in the law were breached or infringed, we could think that the person who belongs to the patronatna služba has to comply with ethical standards of public service?
Так, я думаю, так, якщо
Yes, I believe yes. If the person has chosen the public profession to work in a public authority, despite the fact of being included into the support service and having just the labor agreement, I still think that this person has to comply with ethical standards. For example, because the person works in the Supreme Court or any other court, then yes. Even like at the internal level, at the level of personal convictions, the person has to comply with ethical standards.
I'm just curious, what is your opinion? What was the reason behind establishing this kind of system, that assistants of judges do not belong to public service? Because in many countries, in European countries, assistants of judges are public servants. So it's just curiosity, and what is your opinion? What is the main reason why it happened in Ukraine?
я думаю, так.
I think the situation emerged because the law on the judiciary sets out that the judge chooses the assistant on their own. So, even for example, the assistant were a civil servant, still, according to the current legislation, there should have been the competition for the position of the assistant. Now, the judge chooses the assistant on their own, and he or she can choose people on their own and then hire them as assistants. Of course, this simplifies the work of the judge, selection of the assistant, but at the same time, maybe it's a bit incorrect, because the assistant should be a civil servant, in my opinion.
I would like to ask you about the most difficult aspects of your current work in comparison to your previous experiences, because you've got different experiences, so you have a basis to compare, and you know how is it to work as a private lawyer and then to work not in a public service, but still, as we just discussed, similar capacities. So what is what did you find the most difficult when you got to this position?
Звісно, спочатку було
Yes, of course. Initially, it was a bit difficult because it was difficult to get into this work. I needed to draft decisions, justify decisions, in order to take into account all arguments of the parties. I needed to make sure that judge decisions were fair, because assistants draft decisions. When I was working in the cassation commercial court, there was a lot of work. And you work there like on the conveyor belt, because you draft the decision, then you take another decision to draft. You need to study the circumstances. You need to spend time on drafting the justified decision, etc. It was a bit difficult because while working in the private sphere, you defend interests of one party. You try to do everything possible to defend those interests. And here you need to have this balance of probabilities in order to take into account arguments of both parties and to draft the justified correct decision.
What personal traits, personal qualities would you underline as the most important, your personal qualities as the most important and helpful in your current position, and probably for the position of disciplinary inspector?
I have such a quality as I will not leave the case until I get the result. I always want to clarify everything about the case. So I want to learn all the circumstances, and I want to draft the justified decision. For the position of the disciplinary inspector, the same will be about the opinion. I will need to take into account all arguments and circumstances. I'm also hardworking. I love working. I do not have situations when I don't want to go to work. I'm always looking forward to working. I can even work on the weekend if I have the opportunity. So I believe that these two best qualities that I have, that is love to work and love to study all the circumstances and drafting justified decisions and opinions.
Dobar ranok. As my colleague has been asking you questions, I noticed that you're not using the interpretive devices. You obviously understand English.
Так, я вас розумію дуже добре.
Yes, I understand you perfectly well.
What do you think your proficiency level is?
Я ніколи не робив якийсь тест.
I've never undertaken any tests, but I think B2 level, that is my level.
Opening presentation, when you were asked about your understanding of the purpose of the service, as well as your interest and motivation, you said, "We are witnessing judicial reform and the implementation of the rule of law." What is your understanding of what the rule of law is and how it relates to the SDI and its mission?
Розуміння
The understanding of the rule of law. You know, I really love another Ukrainian word that is called pravovladya. That is when the state is governed by the law, when everything is governed by the law. I cannot say that it's like the legal provisions, the piece of legislation, but these are general legal principles and the law in general. With respect to activities of the SDI, I believe that the rule of law should be the priority for them, and they have to be studying cases and circumstances of cases based on this principle and taking into account not only legal provisions but also fairness, the possibility to appoint, for example, a mild punishment sanction for the person who has committed the disciplinary offense than the one set out by the legislation. And it is also necessary to take into account this principle of fairness and principles of the rule of law as the priority principle.
What is your understanding of what those principles of the rule of law are?
принципи
Principles of the rule of law, in my opinion, as I've said, the law should govern in the state. Everyone has to fulfill provisions of the legislation, but I believe that law includes also moral qualities of the society, moral principles in the society, including, for example, ethical principles if we are talking about judges. And ethics as such is not stipulated in some legal provisions. It has to be governed by internal convictions, internal standards, and I believe that the rule of law, among other things, includes this ethical conduct as well, and is including that of a citizen, of a human being, and the judge as well.
What is your personal experience in investigating cases or complaints against judges?
такого досвіду не було, оскільки
I do not have this experience because even though I work in the Grand Chamber, I work in the commercial jurisdiction. And since decisions of the HCJ are reviewed in the administrative jurisdiction, we just get acquainted with the materials of the case, report to our judge, and we do not draft decisions and we do not study any materials of the cases like that.
If you get hired to this position, how would you approach an investigation of a complaint against a judge?
по-перше,
First of all, I think that it is necessary to study all provided materials. For example, if some materials are provided together with a complaint, it is necessary to study the complaint. It is necessary to find witnesses who can be summoned. If it is possible, it is necessary to interview them. It is necessary to send requests. And based on that, it is necessary to reach some conclusion, draft opinion, and present it to the disciplinary chamber of the HCJ.
Aside from reviewing the file, what else would you do?
As I've said, send requests, interview witnesses, and maybe that's it. Well, we cannot interview the judge. Of course, it would be great and interesting if you could talk to the judge, but that happens at the stage of the consideration by the discipline chamber, and the inspector can ask questions to the judge as well during the consideration. So this is also the element of the investigation, to ask questions to the judge during the proceeding.
My last questions regard your statement that punishment against the judge or sanctions for an ethical violation should be proportional. What factors do you think should come into play to consider what sanction is appropriate?
звісно, потрібно враховувати
Of course, it is necessary to take into account the individuality of the judge, professional activities, personal life outside of the work, circumstances under which this offense was committed, how the judge could have acted in a different way, whether he or she could have acted in a different way, and what impacted committal of this offense.
I'm sorry, I didn't quite get the last one. The impact of the offense?
Which circumstances, which factors impacted committal of the offense, whether the judge could have acted in some other way, maybe the judge could have some other possible options how to behave.
Do you think there are other factors such as the impact that the offense may have had on a third party or public perception of the offense should be additional factors to be considered?
Можливо.
Maybe, but I think that, for example, some public pressure, if this is a high-profile case, then I think it impacts independence of inspectors and the HCJ as well a bit. I think that regardless of public pressure, any media pressure, etc., it is necessary to consider the case taking into account all of these circumstances, regardless of the external pressure from the public, media, etc.
Good morning. My first group of questions would follow up on your statement about your attorney's license. You said that you questioned the license in 2023 based on the decision from May 23 that assistant cannot be an attorney, and you said that you disagree with the decision. Why?
Можливо, я трошки не погоджуюсь.
Well, yes, I slightly disagree. I believe that the assistant should not be a defense lawyer, but I disagreed with the way it was done because there was kind of the discrepancy, because the law on the defense lawyer establishes the requirement that there shouldn't be the part-time job, but the judiciary law does not have this requirement, and the law on the judiciary in the Service of Judges doesn't have this requirement that the assistant to a judge cannot be a defense lawyer. I think the Council of Judges should have prohibited it, but maybe in the other way, or without changing the requirements about the assistant to judges, maybe so to initiate some legislative procedure instead, and change the law on the defense lawyers or the law on the judiciary and the status of judges.
You agree with the substance but don't agree with the procedure, how it was made? Okay.
Indeed.
Okay. And wasn't it enough to suspend your license? You had to quash it, or you also had the possibility to just to suspend and let the license alive? Was this legally possible, or you didn't have another choice but to quash the...
Ні, я зупинив свою діяльність, не припинив.
I terminated it. I didn't suspend it, and that was explained in the decision that you had the right, to just suspend it or terminate it fully. So I did.
So you had both options?
Так, можна було і припинити.
Yes, I had this right. Yeah.
Why didn't you just suspend?
Advokat
The defense lawyer has the right either to suspend or terminate, but if you terminate it, for example, your life condition changed, or if you suspend it, there is some change in the life decisions, you can submit the request to the Council of Judges and you can resume doing. But the whole procedure for getting the license, if you terminate it, you need to do it over and over again. You need to take the training again, you need to get license again, and so on. So it's a kind of lengthy procedure.
I think I'm not getting the core of my question. So you had two choices, suspend and cancel. You chose cancel. You chose suspend. Okay. Now it's clear.
But
I thought that you canceled the decision. Okay, super. So there is a concept discussed among scholars and lawyers, which is called blending of roles. various roles, various oaths. You have one oath for the bar, another oath for judiciary. They say something different, and they also put you in different positions or obligations. How do you feel being obliged to follow both oaths, since you can't suspend the oath? The oath is there. How can you explain your perspective of having oath to two different legal professions?
Так, це дійсно цікава ситуація, така виникає, коли ти даєш дві клятви, можливо так сказати, присягу.
Yes, it's an interesting situation when you take two oaths as a civil servant and as a defense lawyer. And I think that while suspending your activities as a defense lawyer, you don't certainly suspend the oath, but you at least suspend the activities to discharge the duties under the oath. And this is a complex situation. The oath of an attorney is more like a ceremony, like an necessary introduction to the profession. Certainly you are bound with the ethical issues, and this is a controversial situation indeed, but this is the fact we have today, and the law doesn't prohibit this situation. If it is regulated, that you are absolutely banned from having any license, then yeah, it would be regulated in the law.
Of questions, I will ask only one, and if the time allows, I will ask more, but I need to leave time for the second part of questions. So, have you been ever asked as the assistant of a judge by your close family members, friend, former client, or friend of a good friend for legal advice or opinion about some case at the Supreme Court?
Ні, таких ситуацій не виникало, саме справ, що...
No, it didn't happen. As to the cases in the Supreme Court, no one ever asked me anything. Maybe some legal advice on the daily life of my friends or family. Yes, that did happen. Can you please advise me on a particular daily situation? But as to the professional activities, not.
It was not supposed to be about your case, but their case. You know, unrelated to your judge, unrelated to you. I have this case. What do you think? Nothing like that happened?
Ні, не було.
No, it didn't happen. Because most of my life I lived in Kharkiv. Now I live in Kyiv, and I don't have any big contacts, professional ones. And while in Kharkiv, not many people really knew that I worked in the Supreme Court.
Okay. So last part. Let's say you will get this job, you will be more frequently in Kiev, you will build the network of contacts. And this wide variety of contacts will learn, oh, now you are in the judiciary, and they would like to discuss with you their problem or case, the substance of law, or whether the judge which is handling their case is fair or has doubtful reputation. How would you govern your conversations with these acquaintances?
Я вважаю, що коли такі питання виникнуть, то...
Well, when these questions emerge, I think we don't even to discuss them, to talk about them. My position is that if there is an outsider asking you questions about your professional activities, you must immediately stop this conversation and not get involved into it. This is incorrect. And you should not be discussing any cases, not even your cases, or giving any advice. If there is a question that someone asks me, I won't give any answers to that question.
Well, thank you.
Дякуємо вам.
Thank you. Yeah, I still want to ask a couple of questions to build on John's questions about the rule of law.
Скажіть, будь ласка, як ви будете вчиняти,
So please tell us, how are you going to act if there is an ethical dilemma you're facing that will conflict with the principle of the rule of law?
Критичне дилемма.
Well, it's hard to imagine that kind of dilemma, although it may occur. It depends on where it occurs. Is it private life or professional life? If it's private life, then certainly you need to take into account the rule of law and your internal feeling and your life, and follow your consciousness. If it's professional activities, I think you need to remain independent here and follow the rule of law and the letter of law and the spirit of law as well, and do what you're supposed to do. While some personal feelings or ethical matters, they should go to the second importance line. I don't think you need to follow your personal opinions in your professional life. You need to work according to the legality and fairness principle in your professional life. Last question. Have you ever faced a situation when the respect for the rule of law required some unpopular decisions? In professional life, you probably mean. Well, yes, that happened, of course. While working in the Supreme Court, when you consider cases, you sometimes realize that some of the decisions may damage one of the parties, but it should be correct, lawful, and comply with the principles of the rule of law. So sometimes you feel sorry for a person or for a party as a human being, but still you even the principle of fairness may be unfair to some of the parties to the proceedings. So when considering cases, when making opinions and drafting opinions, you need to follow the rule of law, but that indeed may damage one of the parties and would be unpopular. There is always a losing party in any proceedings. So for this party, the decision may be bad, but that's possible. Tell me whether the decision should be fair or lawful, should be the balance. Yeah, legality and fairness should be balanced. The arguments and interest of both parties need to be taken into account. So a decision may be fair, but may be unlawful, and the other way around. Thank you, Valery, for your answers to the questions. Let's move on to the next block of questions. As to the property integrity, I don't have any questions on that, because once again, and thank you for that, you provided all the grounded and well-reasoned answers to our questions. No questions remain as to the property integrity. But there is another question. Since 2015 until 2017, you were a lead legal advisor in a company, and the end beneficiary of it was a citizen of the Russian Federation. Please tell me, at which stage of your cooperation did you learn that the end beneficiary was a government, was a representative of Russia? I think it was 2016, because the law required enter information about the end beneficiaries back then, and this end beneficiary is not a kind of direct end beneficiary of the company. It was the beneficiary of another company based in Cyprus that was the end beneficiary. So when we learned about that, then I became aware of this fact. So as I understand, it was 2016. Okay, and you stopped the cooperation with this company in 2017. Didn't you have some internal, personal dilemma that starting from 2016 and 2017 throughout this year you continued working with this company? The thing is, and I provided my answers and the explanations, this company is not a kind of separate company. It belongs to a group of companies, and this group of companies belongs to a citizen of Ukraine. So this particular company was the end beneficiary, and it was done more for some convenience purposes. And I didn't have the dilemma, because in fact this company and other 5 that belonged to this group were owned by a citizen of Ukraine. All the incomes remained in Ukraine, and this end beneficiary from Russia didn't get anything, as I understand. So I realized I worked for the Ukrainian company, I was paying Ukrainian taxes, so I continued working there. All right. In your explanations to the request of the selection commission, you didn't deny trips to Russia. In 2018, you visited Belgorod.
Скажіть, будь ласка, в зв'язку з чим
Please tell us why.
Як я давав пояснення,
As I explained,
до цієї групи компаній входило
this group of companies included a Russian limited liability company, and it closed down in 2014. But since these companies belong to one group and they cooperated, so when we had a tax audit in Ukraine, I had to go there and get the documents. So they asked me to go there to collect the documents, so that to bring them back to Ukraine for tax audit first. So no doubt as to did you have any doubts and did you have a chance to refuse from the trip? Well,
етично мотивовано правильно.
ethically it was incorrect probably, but at that time the legislation didn't have any bans on that, so I did it real fast. I went back
Нічого не
fast, so I didn't do anything illegal there.
будь ласка, а чи була необхідність саме
Was there a
відвідувати
need to visit Russia? Couldn't you handle it in any other way?
Так, там були бухгалтери навіть.
Well, there were
віддалені від нас.
accountants who worked there in the remote mode, but
Компанія припинила
since these companies stopped making payments to the accountants, so they refused to do anything for us. But we needed those documents, so there was no other way than go there physically and collect the documents.
поштова служба не
So mail didn't work,
вирішити це питання?
so you couldn't do it in any other way. You couldn't. I don't know whether the mail service worked in Russia or with Russia back then.
їх переправи там територію України.
We needed to kind of find them, we needed to loan them to pick up something that we really need and bring it back. How did you do it? Where did you do it? This accounting company that provided services, they kept the document. They refused to do anything with them to hand them over to us. So they had them in their office. I went to their office, got the documents, collected them, and brought them back. Okay, thank you. Another question. 2019 in March,
Поїздку до
you went to Novorossiysk.
яка мета була цієї
What was
Поїздки була
the goal?
обговорювали, які
This company that we discussed with you today, the end beneficiary was a Russian citizen.
оскільки як в українському законодавстві зараз
The,
існує
in Ukrainian legislation, we have such a thing as controlled foreign companies, and they have the Russian. And this company was fined for violating some deadlines for reporting, and they offered me to this to carry out this service, to go there and challenge this fine. And this person who owns all these companies, the citizen of Ukraine, he has this wife, and it was the mother of the wife. So they asked me to go there and challenge the fine that their mother was facing. So I did that. I challenged it, and the fine was reduced. Maybe it's incorrect thing to say, but yes, the fine was cut down, and Russia eventually received less money. Well, you said in your explanation that they offered you. You could have refused. You didn't. Why? Well, I could have refused, but these are the people I was providing services to, and certainly this was my job. If I refused, I would lose some of the income of mine. So it was because of professional services for which I was paid for. It was the income, so that's why I refused. Well, I didn't refuse. So at the moment, Russia didn't have that kind of expert who could have provided assistance in this matter. Well, they did have this matters, but since it was the mom or mom-in-law of the owner, and they knew me, they knew I could do it, they offered me this choice. I think they could have found someone else, but it would have taken much more time, much more money. That's why they offered it to me. So, as I understand, getting money was the primary objective for you back then. Yes, it was. Thank you. No more questions.
Any regard, because the interview is coming to the end, so we can ask any additional questions if you
we started this very different aspect, it's difficult for me to come back to my question. But let's put it this way, as we are discussing the motivation of your activities, and you said that for that particular action you wanted to conduct your business. What are the circumstances under which you would say, even though it's my obligation, even though I will have profit from it, I will not do it? Given, let's say, this particular case.
Те, що ми обговорили зараз, так?
That we have just discussed, right?
Це, звісно, на даний час я би так не зробив.
Certainly, I would not have done it right now the way I did there. I was young, I was 26 back then. I had this drive, you know, as a young person. I didn't think much about this ethical dilemma. You just graduated, you are good with your career, you're getting money, and certainly you wanted to be paid. But had I had the situation right now, I would not do the way, and I really feel sorry I did it back then.
Якщо якесь питання становить
So,
якось
if
потрібно це зробити, але
there is a situation whether that I need to do something, but I have a choice, maybe right now I would be guided first of all by the fact how it may look like from a side, you know, whether it's in line with ethical principles, moral principles, legislation, and then only in the second line you would think how it matches your principles and whether that's okay for your consciousness.
I appreciate the sincerity of your responses. That's a very important thing to say. But let's go deeper. How can we know that you will, in future, do the right thing? That's not yet the question. It's a philosophical principle, or for you to understand why I am asking this. Can you please tell us about the situation from your past where you were on a similar crossroad or was facing some kind of pressure? And can you describe something which was quite serious, and what did you do?
Well, probably I have not had such serious problems when I was at crossroads, so whether when I had to decide to do or not to do. Maybe that's more about professional activities. In personal life, I did not have that. In professional activities, while working as the attorney, the question is about cases that you decide to take part in. Sometimes you have such an issue that you see that the case is, for example, not very fair. For example, a client who comes to you is not very fair. So he demands something that are not fair and that are not right. And then you have to choose whether to cooperate with this client, for example, whether to draft this claim, to file this claim on behalf of the client, being aware of the fact that it will result in some results for the other party. For example, the other party has done nothing wrong, but the client comes to you with this claim and says, let's bring this person to court. That's a legal, ethical dilemma when you have to choose whether you take this case or not.
Last question, but very direct. Imagine you are a defense lawyer. You are representing an accused person of domestic violence. And you found out that he did much worse things than what he is accused of. You will find that the person is actually in danger of her life because of the domestic violence, but there is not enough evidence in the file, and you are obliged to provide legal assistance to your client. What would you do in this kind of tension?
Так, дійсно, це
Yes, really, that's a difficult case. Firstly, I believe that the purpose of the bar, if you defend these clients, for example, the purpose is to make sure that the court complies with the procedure and that the interests of the accused person are complied with. So, for example, while participating in these unpopular, difficult cases, the main task of the attorney is to ensure compliance with human rights and with the procedures by the court. With respect to learning about some circumstances, if we take your example, the attorney is bound by rules of ethics and attorney's secrecy. And if the attorney learns something, yes, as a citizen, he has to inform about the crime. But as the attorney, I believe that he has to preserve this secret. But it is very difficult for conscience, for some internal ethical qualities of the attorney.
I would like to hear how would you think about this situation? What would be your thoughts?
Ну, в першому випадку.
In the first instance, probably I would not even take this case. I would not take this client because my personal beliefs do not allow me to do that, to defend the client.
From the conversations now.
Це буде важко.
It will be a difficult decision, but the decision is that you have to preserve the attorney's secrecy and not disclose this information because you've taken the oath and you have to comply with this oath.
Можна мені коротенько?
May I ask a short question? Can you please tell me? Let's imagine the situation. There is no external observer, like you and your internal eye. Can you please tell me, how would you act now with respect to this trip to Russia to challenge the fine? Would you go or no? Now, I would not do the same way. I would refuse to go. I would not go to the Russian Federation because I believe that any contact with this state should not exist. And for me, now, that is not now, but that's my established belief. Maybe after that trip, maybe a bit later, and I'm convinced that I should not have done that. So I understand that you're like internal self without external observer. So that's like your decision, your belief now. Yes. Thank you.
So the questions are over. So now you have a few minutes to reflect and to say a few remarks if you want.
Дуже вам дякую.
Thank you very much for this opportunity to participate in this process, in this procedure. I believe that it is a very pleasant, nice procedure that is benefiting Ukraine. Regardless of the result, I'm really happy that I've participated in this, and thank you for this opportunity.
Participation in the competition and participation in this interview and answering questions sincerely. So our decision will be made after this week, after all interviews, and you will be notified. So thank you very much and good luck. Добрий ранок, пан Дмитро. Welcome to the interview for the position of the disciplinary inspector. So we will have now the interview with Mr. Dmitro Grigorishin. So first of all, let me introduce our commission. I'm Rada Moliene, the chair of the commission. Today, the commission is in its entire composition. Members of the commission are Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zerlinchik. So our interview will last the duration is about 1 hour. We will ask you some questions about your professional background, your professional experiences, also your insights about judicial ethics and integrity. And also I would like to, and at the end of the interview you will have a chance to say final remarks. And the interview is broadcasted. If you have any information during the interview which falls under restriction for its public disclosure according to the martial law, please inform the commission accordingly. Do you maybe have some questions, requests? No questions so far? Дякую. So then we can proceed with the interview. So first of all, we would like to ask you to introduce your professional background and your motivation, understanding how do you perceive this role of disciplinary inspectors. So you have up to 10 minutes for this. Thank you. And please, would Laska speak slowly that our interpreters would be able to interpret and to translate everything that you say. Thank you.
Yes, thank you. Thank you so much. My name is Dmitro. I have over 10 years of experience in the bar sphere as the attorney, and participation in this competition has brought me down to earth a bit. The matter is that I believed that one of the easiest stages that would be the easiest for me, that would be the practical assignment. And coming to the practical assignment stage, I realized that 2.5 years have resulted in the loss of most skills which I thought to be very easy for me. And this has brought me down to earth. I believe that that is quite a low score for the practical assignment that I've received, but basically that's objective. I also compared answers. I also checked the key statements. So with respect to yes or no, mostly they corresponded to answers given by those candidates who received higher scores. And then I had a question. If I had a low score for practical assignment, how can I even go to the interview in order to present myself somehow? Because it's not enough just to say that I have experience. The matter is that when I asked this question to myself, I thought, I recollected that when I was preparing documents for submission for the competition, I had time, because back then I was at rotation and I was reading documents of the High Council of Justice. And I recollected that I read one of the documents by the HCJ. I read it in April and I found it later on and I reread it again. And it was so memorable for me because in this case the judge was not brought to responsibility, but when I was reading the document I noticed one phrase. The check has not found any evidence that some offense was committed, but we check. I did not understand for myself, so I did not see which actions were undertaken during this check. And this document did not mention that. And also I asked myself, if I want to work as the inspector, how would I approach the situation? Which actions would I undertake in order to reach the conclusion that there are no signs of disciplinary offense? I studied this document that is dated April 24 of 2024. No, sorry. Yes, that is the document I'm talking about. The matter is that this decision concerned a complaint against a judge when the judge released the person from responsibility when this person was being brought to Article 130, that is for drunk driving. And because of the insignificance of the offense, the judge made just an oral warning. I understand for myself that, and it's nicely worded in the document of the HCJ, how the judge should act while resolving this category of cases. So what the judge should do, should study, pay attention to. It is also specified that Article 22, which provides the opportunity to the judge to release from responsibility because of insignificance of actions, does not contain clear criteria. So while fulfilling duties, while studying the case, the judge may release the person from responsibility, and until a specific moment there were no objections against that. Then the legislator introduced amendments to this Article 22 and added 9 clauses when judges were not allowed to release from responsibility under specific articles, and this Article 130 was included into the list. The judge was not brought to responsibility because the judge applied this sanction only once, and secondly, because it was necessary to justify. So, firstly, the judge, with internal conviction, decided that this person could be released from responsibility. Using the unified register, I checked all the cases considered by this judge, and there were 137 cases under this category. And then I thought whether this judge used this requirement in other cases. And using other such criteria, I got a lower number of cases, and I noticed that the judge used this Article 22 with respect to other cases as well. But during this particular period of time, there were no cases when she could not use this article, and that was by the new year. But I found one interesting case. In this document, members of the HSA clearly state that it is necessary to describe why the judge releases the person from responsibility, that there should be given a list of circumstances. And I found the resolution when the person hit a deer while driving, and this person was under disciplinary sanction. And in this case, the judge stated that the person failed to appear at court hearings, and then just 3 lines that the person was released from responsibility, but without motivation. So, how I understood insignificant offense? There is no harm. With some actions, the person shows that there is no significant harm. But I did not see that in this decision, and there were no words about the deer. It was just stated that the vehicle was damaged. But as far as I understand, the animal died in that case. And if the person released from responsibility could provide, for example, some evidence to prove that he donated some funds to some charity foundation which is taking care of wild animals, so that the person took some actions to undermine the harm, then this person could be released from responsibility because of insignificance of offense. Then I checked using other criteria for another year. And there I found a case where the same judge, when she told the HCJ that she did not use this article, but I found the case when she applied this article to the article where she was not allowed to do that. In this case, we are talking about Article 126, Part 3, and I was surprised that there was no justification as well. And I thought, okay, I will go further, I'll check further. And then I found 2023 considered by this judge, and then I found 3 cases where she could not apply this article, but she did that. So I reached the conclusion that in this case, It's necessary to study the disciplinary case itself because it was stated in the ruling of the HCJ that while giving explanations, the judge pointed out that she did not abuse this article, that she used it once to this category of cases, and that's it.
And that there were circumstances about the caseload of the judge, certainly, but I found the fact that in this case they didn't, that wasn't true. So I thought, if I were a disciplinary inspector, I would certainly explain that in the draft opinion, all the circumstances. I would compare them against the explanations of a judge and would provide that to the members of the ACJ to evaluate. And we could also ask questions to the judge. How come it happened? I mean, you say you don't apply the article, but still you do. In those 4 cases where I found violations, if you explore them in detail, you would understand that the offenses did happen. So you can't dismiss the appoint the dismissal, but the judge did that, although she said she didn't. So I kind of thought that in this case, this category of crimes has a huge corruption risk, because if you can apply them in this way, and if someone doesn't pay attention to that, it doesn't notice, then those cases would not be investigated by anyone. And then I thought, how is it? How does it happen all across Ukraine if that kind of case happen? I think there can be up to 9 articles where you can apply the principle of insignificance. I took only one when the judge brought responsibility to the people for driving under substance.
It's already run, so if you could just wrap up your introduction, that we could start our discussion. Thank you.
Так.
So in this case, I found that in Ukraine, under this article, there are a lot of cases when judges all over Ukraine apply the sanction without having the right to dismiss people, so they limit themselves to the verbal warnings. There are first instance courts and appeal courts, but these cases cannot be cassated. And I think that when an inspector considers in every case with that level of detail, he can see corruption-related risk and bring them to the attention of the HCJ members. So if we talk about the further work, because this is a new service, we in legislation have such a thing as anti-corruption checking of legislative acts, when a particular legislative act can lead to certain corruption-related risks. And I think we need to raise these questions when people are restricted in their rights to because of the insignificance of cases, and these cases don't go to the cassation courts or courts of appeal because of their insignificance. And then you can do otherwise. And if I were a disciplinary inspector, that's what I would do. I would show all the cases that happened all over Ukraine, and since the law took effect until the moment I actually looked into these cases, and I would provide this information, and under the Article 49.10 about the HCJ, the disciplinary chambers can initiate new cases if they find grounds for that or not. So I mean that any disciplinary case contains not only the element related to certain legal relationship, but it can have can give a general understanding of what's happening all over Ukraine. And if we pay attention to that, we can improve the situation.
To interrupt you, because we want to start our questions, which are also related to your introduction. Thank you. And I would like to start from this question, which is directly related to what you just have explained. So, as I understand, your motivation to come here is related to your understanding that those disciplinary cases could be held in a different manner, having in mind all the context and having big picture in mind. And you provided us with your investigation about a particular problem in disciplinary practices. So, how do you think why the new service has to be established? Because these kind of things that you just said and those actions could be also done in the framework of existing. Well, we have High Council of Justice, we have the people who are supporting members of the High Council of Justice and doing those investigations. So, what is, in your opinion, the main aspect which makes this new service different from existing system? And please be concise and short in your answers so that we could continue. Thank you.
В даному випадку це дуже важливо.
I think this is an important service related to the cases when judges may be brought to disciplinary responsibility, and an inspector is going to be an active participant of disciplinary proceedings. If we talk about the decision that may be taken against particular judge, we see that the criteria for selection are really high and the commission is totally independent. The HCJ members are selected according to different criteria, and these criteria of selection are different because the independence is based on different criteria. And I think for disciplinary inspector, he's gonna be kind of independent and separated from the such an institution as a HCJ that makes decisions on the merit.
Thank you. And then I would like to ask you, what are the main legal acts, regulations regulating this judicial ethics?
Bangalore principles, the legislation of Ukraine on the High Council of Justice, the Code of the Judiciary Ethics.
So, and then I would like to ask you, because there are many principles and in the Code of Judicial Ethics and Bangalore principles, they envisage quite a list of those principles. For you personally, what principles are the most important, or those who are like you are referring mostly? I mean, judicial ethics.
Independence and competence. A person must feel that he or she is totally independent when the decision is made based on the circumstances, and the competence is required so that he could make the decision with due expert level, with due professional level. I think these are the two major aspects for the judge.
Now I would like to ask you about your opinion about the relationship between the ethics and the possible offenses which could be a ground for disciplinary liability, but also which could cause some administrative liability or even sometimes criminal liability. And I would like to give an example, and how would you see this if we have a ground for the disciplinary liability, the possible breach of ethics. let's imagine that we have a situation that a judge is stopped by the policeman, and it appears by some investigation with an equipment that the judge is allegedly under the condition of alcohol intoxication. And then the case goes to the court, and courts decides that well, there is no the case should be closed because well, the protocol is not correct, and also there are some doubts about maybe the equipment. And then the disciplinary inspector gets a complaint from a subject of who can complain that well, in fact, the judge was in this condition, and it is proven by statements of the policeman that there were also different kind of circumstances that prove him to be in this condition. And also his two colleagues, they state that just before the judge drove, they had a lunch, and the judge had 3 glasses of wine. And just after 15 minutes, he was stopped by the policeman. So in this case, but the case for disciplinary, for administrative offense is closed. No evidence, well, not enough. So how do you think? Is there a ground for a disciplinary liability of a judge in this case?
Well, in this case, certainly the judge will refer to the decision of the court. That does not indicate that the administrative liability has been committed, but this is actually the whole idea. So that disciplinary inspector of a SDI could evaluate the all totality of the actions of the judge, and if there is evidence, like witnesses, as you say, who can confirm certain circumstances, you can also analyze the video evidence from the body cam of the police officer. You can look at how the judge behaved, whether he answered questions in duly manner, if he agreed to be tested, and how he did it, how he answered questions at the scene. So if there are enough grounds that corroborate that indeed the judge was driving under influence, and if a reasonable observer can be certain based on the evidence or witnesses and the explanations of the judge of that, and if you analyze the whole variety of the circumstances of the case, because it is necessary also to see what judge used, what kind of evidence the judge used to not to bring him to responsibility. This totality would lead you to the understanding whether there are enough grounds to bring the judge to disciplinary responsibility.
Would you think it could be the ground for dismissal of a judge? This kind of infringement of disciplinary.
Таке порушення.
Yes.
Ну,
Well, in any case, we have clear-cut criteria for that. If a judge needs to be kind of a role model of behavior, and she considers similar cases where other people are brought to responsibility, then I think, yes, we would need to raise a question about the dismissal of that. Thank you.
I would like to give the floor to my colleagues and the opportunity to ask some questions. Yulia.
Good morning. I want to build on the Reda's case. we talked about a case when the person is driving under influence, right?
І ви ретельно, я так бачу,
And in quite a lot of detail,
познайомились
you
з практикою дисциплінарних проваджень.
have studied the disciplinary proceedings,
Скажіть, будь ласка,
case law practices, as I understand. So please tell us, in your opinion, what is the objective of bringing judges to disciplinary responsibility?
це, наприклад,
For
чисельні
numerous
звільнення з будь-яких причин. Можливо,
dismissals,
строку не вистачає,
for
повідомлення сторони
reasons
щодо
like,
розгляду справи від даної відповідальності.
for example,
Відповідальності, так.
oh no,
Ну, особи, яка вчинила
I mean the. We're talking about the Article 130. This is administrative responsibility, and there are so many cases of judge that when the judge denied case, if you analyze the like 40, 50 cases that the judge judged on and denied the case, so it doesn't make sense to bring that kind of judge to responsibility. And why? What is the objective for bringing them to responsibility?
формально
Because I mean, technically speaking, we can say that well, maybe everything was valid.
суддя направила
That the
повідомлення,
judge kind of sent necessary requests. People sometimes may fail to get them, or the defense lawyer asked to postpone the consideration of the cases for different reasons, and that led to violation deadlines. So please tell us, if we bring judges for the disciplinary responsibility, what could be the objective for it?
Якщо було дуже багато справ,
Well, if there were indeed a lot of cases and if the judge denied the case and didn't bring people to responsibility, that was the matter, the substance of the question, correct? Yes. We need to investigate each case because there should be the grounds that the judge used for the decision. So in each case, we need to analyze it, and the inspector needs to do that, to analyze, to describe, and understand the grounds of a judge, motives of the judge that motivated him to make a particular decision. The judge makes decisions in the deliberations room and follows his personal beliefs. We understand the level of trust to the court, to the judiciary is low. We understand that, but sometimes it does happen that people believe that white is white, but in court decision, out of a sudden, white is called black. So what I mean is we need to describe every circumstance that you have analyzed, and it is the disciplinary inspector who need to provide persuading argument that he believes indicate that the judge acted in a dishonest way. For example, the judge totally ignored something and didn't specify it in the decision. So what I mean, if there are no grounds, it would be hard. But if it's only one case, it would be hard for us to understand it. But if you look at 40 cases, you would understand the logic behind the judges, whether they have integrity or not. No,
все понятно.
we understand your answer.
Відповіли. Скажіть, будь ласка,
We understand what you mean,
мета
but
цієї
please tell me the objective of bringing judges to disciplinary responsibility. What kind of
щось
objective is that? Like
керувати суд,
just to have some discipline in court, or is that like does it have a civil society dimension, whatever? Well, it's about prevention, yeah, so that other judges could see that if they commit certain actions and this judge is brought to responsibility for that, I think the judges read the case law as well, and they will have already some kind of understanding the criteria, the framework beyond which they are not supposed to go. And purification is another thing, because if a person makes decision not based on the circumstances of the case, but following some dishonest motives, even if there are no grounds or evidence or bribe or something, but still you can see some patterns. And if you describe that, I think that would be the objective, to purify the judiciary from the dishonest
коли він бачить, що за
on it.
130
But if we take a reasonable observer, if they see that you drive under substance and we see that the judge brings people to responsibility, what
якось дисциплінує,
is this case about? Maybe that would bring others to discipline, that they're not supposed to do that, that the punishment is going to be inevitable.
Це найголовніше, що може бути.
Yes, this is the most important thing that can happen in the society, because
Суспільну думку, сприймаючи
as I see, there is a kind of general prevailing idea that some people believe you can just pay and avoid the punishment. But now there isn't such a definitive understanding that this is possible any longer, at least now. Yeah, sometimes you listen about that still happening, but it's at least the general public doesn't believe that this kind of attitude may prevail. So I think there is still some kind of a trend
люди вірять в те, що
that people tend to believe that for that kind of cases, that kind of offenses, people firstly must be brought to responsibility, and second, that perpetrators will definitely be brought to responsibility. No way they can avoid it. And I wanted to show that there are not so many of the cases. Yes, they did happen over these years, but not more than 10 over a year. And that's related to the first instance court and courts of appeal. So you mean it if someone sees that there is punishment involved, he or she would think twice whether to start driving under substance or not. Second question.
скажіть, будь ласка, якщо у вас були такі випадки,
Please
коли ви доводилось самостійно
tell us,
вживати?
have you ever had a case when you needed to make decision independently, and what was the result? I mean, you make the decision independently.
Ну, якщо були такі випадки, коли
Has there been any case, when any situation
ви маєте приймати
where you were supposed to make
рішення
a decision
в колективі,
in your team?
якесь можливо розпорядче, можливо
Maybe some resolution or something. Well, the last decision I made on 28th of February, when I
безпосередньо
on 2022, I went to the military recruitment center.
розумію,
That was the decision I made to defend my country. I understood that there was no other way for me.
багато людей, які
And there were
таке ж рішення
a lot of people back then who made that decision. There was a whole line of people. They didn't know what to expect in the future. How about your professional life?
діяльності, професійній діяльності. В мене була справа, коли я
I had a case when I defended a mayor,
діючого міського
city
голову,
mayor.
зняли з реєстрації
He
виборів.
was delisted from election list.
Процесі досить скорочені.
In the electoral process, the terms for the preparation of a claim are really short. I prepared it and I won the case. And he offered me to be his deputy, but I refused. But it's not something I want to do. So I just decided that I want to deal with the professional. I want to do professional activities as a defense lawyer.
до прийняття рішень,
When and how do you make decisions when you
можливих варіантів.
have different ways to go, different options?
Я вважаю, що потрібно діяти по закону
I think you must
або по совісті.
abide by the law or your conscience.
Якихось ділем тут бути не може.
Conscience. There are no other options, no other dilemmas.
Розумію, що
So you understand. You need to understand that there is no other kind of option for you, and there is no dilemma.
ти вважав, що це по совісті.
I mean, that should be according to the law and according to your moral integrity.
Коли потрібно прийняти
What do you do when you need to make fast decision under stressful conditions?
В умовах високого стресу
Under stressful conditions, I make the decision.
маю рішення, яке безпосередньо
чим керуєте.
What drives you? What guides you? I am guided by the law, the circumstances, my common sense, and I go forward.
немає іншого вибору.
I mean, there is no other choice.
І останнє питання.
And the last
Скажіть, будь
question.
ласка, чи були випадки, коли
Has there
етична,
ever been a
дилема
case when an ethical
вам
dilemma made it difficult for you to make the decision?
Етична дилема.
An ethical dilemma.
Ну, я от, якщо я правильно зрозумів,
Well, if I understand your question correctly,
потрібно поступити
it's when you need to
якими, да, чи як?
to make a decision not to enjoy some benefits or something.
Я єдиний
I mean,
курсу,
I'm the only person
мені запропонували працювати в юридичному інституті.
from my year who was offered to work in the university that I graduated from, and that at that point of time it was a job that you could possibly dream about and you could write your dissertation, but I understood that without any practical experience I wouldn't be able to become
Якимось чином
a scholar
привнести щось нове.
and I wouldn't be able to contribute anything new to the legal science, and I
Працював на стройці
refused. I went to work as a construction worker with a diploma cum laude from the law school. And I had worked for about 6 months, and then after competition I took a job where I worked already profession according to the legal profession. And this was a dilemma for me, when you follow your own beliefs and without trying to grab something that may give you more kind of benefits.
Пане Дмитро,
Hello, Mr. Dmitro. Can you please tell me in your own words and very concisely, please? So, what's the key purpose for the creation of this service, and is it really necessary in Ukraine? And how do you see yourself in this service? The purpose of this service is firstly to improve perception and trust of both judges in the disciplinary body and of the society as well. This service has to fulfill an independent role with respect to collection of some specific data, with respect to evaluation of this data from the perspective of preparing draft opinions, and when the service suggests to bring the judge to responsibility, because the legislator has also set out the possibility of return of opinions if there are some shortcomings or when the punishment does not correspond to some criteria. Personally, in case of me, as the inspector from the professional perspective, give me any case right now, and I will be able to decide which evidence is to be collected, which witnesses are to be interviewed, what has to be done. I will prepare the draft opinion, and even now, I could professionally address this task without any fear. The only thing is that really, initially I would try to study previous decisions of the HCJ. I would try to find connections, ties with similar cases. I would analyze them, and I would try to find the truth. Thank you. You've said to improve trust, and do we have a low level of trust to the HCJ, a disciplinary body, from the judges and the society, in your opinion? Let me say, when a person is interested in something in the internet, you can receive like a selection of suggested news. In newspaper Law and Business, there was published an article by a judge about the judiciary. It's a very fresh article, and I tried. I'm sorry for interrupting you. I'm asking about your opinion today. From this article, I see that there is some distrust from judges. From article, that's okay. What about your feeling? What's your observation? You are the attorney after all. As of now, the High Council of Justice has renewed its activities with respect to the judiciary community. I do not feel any negative or positive attitudes because, firstly, I'm now in another environment, and from the perspective of the society, there is still some distrust in any. If you hear the word court, judiciary, or some other similar words, people have some distrust now. So you're convinced that with the creation of this service, the level of trust will increase. I believe that yes, it will. Let me explain why. Okay, I understand your point. You've also said that now you're already ready to consider the disciplinary complaint and perform some actions set out by the law. Have you realized that after getting this relatively low score for practical assignment? Or when did you realize this? In this particular case, the practical assignment was more about questions related to acceptance for proceeding, and it is necessary to work with these legislative bills in order. 2 hours is not enough. The assignment was extensive, you need to read, think about that. And for myself, I realized that it is more important to be able to analyze actions and cases with respect to which you get complaints. Okay, thank you. So you are convinced that today you are capable of considering the complaint at a high level? Yes. Okay, another question. Can you please tell me, in your opinion, why has the legislator set out requirements to candidates to this service to have this compliance with judicial standards? Why do we have this requirement in the law? That's about the fact that judges have no doubt that people who are dealing with cases with preparation of materials for the disciplinary proceeding comply with the same standards as judges. Okay, thank you. Thank you. And my last question to you is the following. A case study. It is not a secret nowadays that many judges serve in the military, in the armed forces of Ukraine, defending our country. Let's imagine the situation that and the judge is under 2 oaths as a judge and as a service member. And in the military unit, with respect to this service member, who is the judge, there is prepared the administrative report on being under the influence of alcohol. The case is considered in the court. The court does not specify that this person this service member is under influence of alcohol, but just points out some shortcomings. But at the same time, since this person is also the judge, the disciplinary inspector, you, in this case, gets the disciplinary complaint for consideration. What are your actions? In this case, it is necessary to study all the circumstances, because unfortunately, in the current context, a person serving in the military loses previous social status, regardless of who the person was before joining the army, regardless whether this person was the director of the bank, the judge, the attorney, etc. At once, this person is put at the level of hierarchy set out by the military service. Unfortunately, we have such instances when commanders use those leverages that they have in order to bring people to disciplinary responsibility, in order to retaliate against people. And that is done due to different reasons. And this way, especially when we are talking about military units, when the person is completely deprived of these. Okay, what are your actions of as the inspector with respect to the specific complaint? What are you going to do? I will send requests. I will send requests to the military unit. If possible, I will get video evidence that is available. I will check all the materials related to the case based on which the person was brought to responsibility. I will get the explanation from the person who is the person in this event. When I see how the events took place, then it is possible to decide whether that responsibility was lawful or not, because no one prohibits to prepare the disciplinary report against any person, and for that we need to have some preventive measures, witnesses, video recordings, and in military units it's even more complicated. Unfortunately, there are instances when they retaliate against people in such a way due to some own reasons and in personal interest. Sorry again for interrupting. Now we are not talking about actions of the commander of the military unit. Thank you, but I would like to point out that when I was the military in the military, I have not lost the social connection with my social statute. Let me explain, please. No, I'm passing the floor to our colleagues, so we have limited time, so I'm passing the floor to others. Colleagues, I don't have any other questions, please.
I'll just ask one question. Good morning.
Доброго дня.
We obviously have many candidates for these positions. What, in your opinion, makes you particularly qualified to act as a disciplinary inspector?
Дякую.
Thank you for your question. Particularly, I do not consider myself to be particularly competent. I'm a human being, I'm a lawyer with a specific background. I used to work in the civil service, I was the advisor of the mayor on legal issues. I was also working as in the private sector. I have quite significant experience of providing services regarding protection of socially vulnerable groups of the population against the state, so-called secondary legal aid. And I also have this experience as an attorney, and all of this gives me the understanding and regarding any court case. Like for myself, I've realized that especially when we are talking about people who want to be inspectors, they need to have practical experience, and they need to have experience of working with judges, because you get to understand a lot about integrity or lack of integrity with respect to decision making when you have been the participant of the process, and when you see evidence that yes, really the law is on your side, but the judge takes, for example, another case not in your favor and the favor of your clients, you start thinking, you start evaluating, you start submitting cassation complaints, appellate complaints, and the experience of drafting these complaints, the experience of evaluating judges' actions under specific cases gives you the general understanding how you would evaluate the complaint from other people when you work as the inspector. So I think that it gives me the understanding that I will be able to perform these tasks. And for me, it will be like sort of usual work, because I also drafted all the appellate complaints and cassation complaints on my own, and I see how specific decisions are taken and how they are described in decisions. So I would be able to prepare the draft opinion that could be submitted for consideration of the disciplinary chamber of the HCJ.
Good morning. My first question is this. If I understand correctly, you had the license to practice law and it was suspended in May this year. Is it true?
The matter is that I read on the page of the Bar of Ukraine that there was a decree of the chief commander about the obligation to suspend the attorney's license. I did not look for this decree, but I saw some articles like that, and I thought that I did not have the opportunity now to wait until I get the order from my commander, so I decided to suspend my license. But I did not use this status since I started serving in the military. So I just saw that there was this requirement published. Personally, I believe that maybe there is some nuance, because when I was told that to come and start serving in the military, I immediately notified my colleagues. I sent them this notification that I'm leaving and I will be serving in the military. And maybe the legislator could have set out that not people have to submit their applications on their own, but maybe it should have been done in a centralized way, that it should be somehow centrally regulated.
You mentioned, with regard to my colleague's question about public trust, you started to point at some article in Law and Business about some doubts the author had. Can you be very concise in your answer? What was your point? What were you going to say in this regard?
Я хотів сказати,
I wanted to say that in this article, the author says that bringing judges to disciplinary responsibility only for their quashed decisions results in the cancellation of the essence of the understanding of the judiciary, or leads in wrong direction. Why did I pay attention to this article? I'm subscribed to the Telegram channel of the HCJ, and I do not see that judges are dismissed for their decision being quashed. And this article was published 2 weeks ago, and this article forms the opinion of judges that there is such a practice, but I do not see this practice based on the decisions of the HCJ. Maybe I do not follow all the events in the HCJ. It's possible, but based on those news from the Telegram channel, when there are notifications about retirement, etc. And just recently, when the judge hit a boy, then this judge was dismissed for this. But I do not see that many cases of dismissal of judges as in this article. And this article is quite extensive and long. It is necessary to read it thoroughly. I just looked at motives of the author, and there are no references here, because the author includes many references to literature sources, and there are only 3 references to decisions of the Supreme Court of Ukraine, and no references to decisions of the HCJ, which could prove that this is systematic phenomenon. So maybe this article should be studied in more detail. And in the Service of Disciplinary Inspectors, if it's preferable to organize round tables with judges in order to discuss such things, if there are such things. So, for example, if we see that there are no facts like that, but there is some publication when judges say that they think that this exists, it is necessary to discuss that and to explain that. And I think that a round table with respect to this article, which states that there is such disciplinary practice, would be really useful.
I have more questions, but I'm looking at the time, and I will pass. And if there will be time, I will ask one more.
Thank you. Thank you for your answers. And I would like to then to go to the second part of our interview with regard to integrity. And well, you provided explanations to our additional questions regarding your property integrity and other questions. So thank you for providing those explanations. I have a couple of questions regarding your first monetary assets, from 2017 and on, you declared significant amounts of cash, over 50,000 US dollars and significant amount of euros, etc. And also the same or similar significant amounts are possessed by your mother. So, and there are no evidence about the source of those cash income. So could you please explain this situation?
Yes. I received these funds immediately after the death of my father in 2014. These were his savings. The matter is that my father used to work in the gas industry. Now, people pay both for supply of gas and for gas itself. And back then, my father was in the cooperative. It was one of the first cooperatives which was supplying gas for people. They also dealt with different businesses, and they went abroad as well. And I learned about these funds after his death. So I didn't even know that he had them. But thanks God, firstly, my parents had savings, and we have them. So these are savings.
Did you, according to the law, did you have to declare that you found kind of inherited this amounts of cash from your father?
Ну, в даному
In this case, I inherited real estate. It is specified in the certificate on inheritance. But since the law does not have this requirement about cash funds, I did not specify that. And when I had to declare it, I knew that I had them, so I declared them in the declaration.
Give an opportunity for my colleagues to ask if there would be some questions regarding this first point, but I would like to go to the second point, which is your income from your practice as a lawyer, which is, I will not then refer to a particular amount, but it is very small, like over 10,000 hryvnias over 7 or 8 years of your practice as a lawyer. So, but at the same time, you refer that you had a significant practice. You were practicing. You were writing appeals and cassations, and that's so you were representing your clients. So, how come?
Ну, я прошу також звернути вашу
Well, please note that I didn't have a chic life either.
дійсно були певні такі
Certainly, these were hard times.
не беручі.
Sometimes I worked without charging clients because for me the most important thing was to get some experience.
Кошти, які я заробляв,
There was money that I made while providing services from the side of the state. So I provided all the reports, and I was credited with the money for that, and I declared them duly. So I worked as much as I could and survived as much as I could. That was kind of life we all had back then.
тобто я нічого не
So I didn't buy anything big, because sometimes a person doesn't make any money and then buy something posh. I was just trying to make some money for my living. Yeah, and I had some money saved also.
We are talking almost nothing. So, so you were, in principle, you were providing services pro bono all those years or almost pro bono.
Так, так.
Indeed.
The follow-up question arises to me. Then, what was your source of living, of survival, if you don't get any income?
Ну, допомога, заощадження.
I had some money saved.
Це теж була
My savings.
підприємницька діяльність.
It was in entrepreneurial activities. I did worked as an entrepreneur because, I mean, there are risks. Sometimes you earn a lot, sometimes you don't earn a lot.
Я нічого ні
But as I say, I didn't buy anything big, no vehicle, not any expensive property.
чином я міг маніпулювати.
So I didn't manipulate anything. It didn't happen.
Some people were like supporting you financially at that time. You mean this, right?
Батьки
My parents helped me.
And also you were an owner of the enterprise, which was construction, basically, development of buildings. So it was established in, I think, 2020, and was active till 2023. Last year, you liquidated this. So during those 3 or 4 years, no income from this enterprise shown.
дозвольте пояснити.
I will explain.
Що наразі будівельні
The thing is, the construction business is developing now, but sometimes people take part in tenders, open calls. They win the tenders from the government and they provide services and get money for the services. But a lot of people work in this way if they know personally the mayor or someone with influence who organized those tenders. I didn't know these people because I sometimes ask these people, oh, why don't you take part in the tenders? And they tell me that it doesn't work that way. You need to agree with someone big. And I remember I told them, let me open up a company. I will take part in tenders because other people they just didn't want to have some quarrels with mayors and others. So we did, and I opened the company and tried to take part with these people in these tenders. But they told me we don't want that any longer. Everyone will understand that still it is us who is bidding. So it was my hypothesis that you can really go to tenders and try to win them without being afraid.
Any project, any development project? Zero projects, right?
На рівні от іменно договоренності
On the level of agreement, I mean, I see there is an open call, and I tell these guys, you guys, you know how to work. Let's take part in the tender. Let's prepare the documents. Let's try it. They looked at that and said, no, we asked some people and they say, no, we don't want that. We don't want to give any price. And according to the law, you can do that because otherwise we can get wrangles with the government.
Public procurement projects, but no any private projects. I mean, zero projects during those 3 years. You haven't had any development during those years.
ну, це було на рівні ідеї.
It was the idea, yeah, only on the level of idea. And then the coronavirus started, and then the war. And I think you can win open calls, you can win in tenders, even without knowing personally the local government. But people are kind of afraid doing that. They say, okay, we win something with you, and then still they will not let us do that. They'll put some obstacles in our way. So that was a kind of idea, you know, to start doing. No,
Дякую. В продовження цієї теми,
to build on this.
в якому році ви заснували?
When did you found this company? In which year? 2020, I think. 2020, I think.
У вас так багато компаній, що
You have so many companies, you don't remember when they founded this one. As I say, it was an idea. I didn't work with that. I just explained to these people that if you are scared to do it, okay, it's 2020. Yes, I think it's 2020. Mike.
If we have time. Yeah, please go on. Please go on.
So, and also I would like to refer to the case of administrative offense, which was closed in the court. And we already discussed similar situations and hypothetical situations, but we have like information about the case where you were accused, and it was last year, last November, that you were allegedly were in state of alcoholic intoxication, and in the military unit, in location of military unit. But then the case in the court was closed because of the lack of evidence, because the protocol was not in line with requirements and some other formal requirements. Could you please tell us about this situation and circumstances of this incident, so to say?
Так. В даному випадку це була чисто
Yes, in this case, it was an attempt of the command of the military unit to kind of break me in an illegal way. You can check out the materials of the file. You can see the date of the decision made and the date when I was transferred from this unit to a combat unit. This unit is, I mean, we were protecting, guarding some object, and some not good things were going on there, and I indicated that, and they wanted to bring me to responsibility. But in the decision of the court, I clearly stated that I disagreed. Why? Because they could video record me. That was their right. If the person is under substance, you can videotape him and show him. It was a totally falsified, rigged case. I explained that in my explanations. And on the 24th, I think it was the court session, and they made me go leave the Harrison, so they couldn't even go to the court. So I tried to explain everything for the judge, and the judge explored everything. He saw what was happening. The case was not in line with the reality at all. It didn't happen. I was not under intoxication. I was dependent on these people totally. But since I wanted to really discover the truth, they wanted to break me. When they saw that they couldn't break me, they just transferred me to another unit, and now I'm with the unit where I'm stationed where I perform combat duties. Please tell us, let's say there is this case sent to the Service of Disciplinary Inspectors, alleging that a judge was under alcohol intoxication, and the judge says, well, the case was rigged. Everything in the case was wrong, and they just wanted to break me. They wanted to put me under pressure so that I made some incorrect decision. So let's imagine. Do you accept this case or not? Do you trust this judge or not? Or you do something else?
Обставин. В будь-якому випадку, при наявності теперішнього розвитку техніки, якщо людина перебуває в якомусь стані, у поліцейського є бодікамери, які
If we live in the modern times, there are devices that you can use to video record a person, and if the person was indeed under the substance, there should be evidence, persuading evidence that would indicate it happened. And if a person who prepares the protocol, you can write anything, even if you are next to this person under intoxication, and then you can try and do anything with that. But I think you need to thoroughly investigate all the circumstances of the case in actual detail. And it's not always when a protocol is prepared, it indeed describes something that actually happened. The video cameras do not show that the judge was sitting with the steering wheel. I'm just giving you an example. Yes, the judge was under intoxication, but he's next to the car. But on the video, you don't see that he was coming out of the car from the side of the steering wheel. Well, how did the judge behave? Did he agree to be tested for alcohol intoxication? If the judge says, no, I don't want that, I want to go to the hospital and so on, then it may indicate that there was some dishonest intention. So a person who knows that he is right, he can say straight away, yeah, please test me. So if that happened, then you need to take it into account. Were you tested? Yes, I was. Thank you.
Thank you. We already exceeded our time limit of this interview. Would you agree if one more question would be asked, just to prolong for several minutes? Is it okay? Okay, so please follow.
Thank you very much. I would like to ask one hypothetical case. I would like to see how do you think about things. We speak about corruption usually when somebody tries to corrupt somebody who has power. I know about a case where the corruption happened among attorneys. One attorney was representing one client, another was representing another client. And the second attorney came to the first one and said, if you convince your client to change his testimony in favor of my client, I will pay you 100,000 euros. And this attorney said, that's tempting, but I don't like it, and started to cooperate with police and collected evidence about this communication. What, in your view, was the right thing to do? Because one opinion is, oh, this attorney, when she cooperated with police, she breached the obligation of confidentiality and collegiality within the bar association. And others say she did the right thing because she revealed important information about how justice works in this case. What would be your perspective?
Well, in fact, I think that the attorney who offered the bribe, well, he is not worthy the title of attorney. He should not be called the attorney because you must abide by the law and follow the rule of law concept.
Because of time, we are not speaking about the offering attorney, but about the action of the attorney who was offered and then started to cooperate with police, while she was bound by the collegial rules to cooperate with attorneys and to protect the confidentiality of everything she learns. So what do you think about her action to actually go after her colleague and communicate and cooperate with the state police against another bar member? Did she do, in your view, the right thing, or she breached some regulations, professional, or the truth is somewhere in between? How do you think about that?
Я вважаю, що
I think that in this case, this person didn't violate any ethical standards as pertains to the other attorney. I would have done the same. There is no violation whatsoever. The proposal as such to commit that kind of actions is a crime as per se, and you need to inform about any violation. And I don't think there should be any corporate relationship in that kind of case, because if we...
She allowed her phone to be wiretapped in order to have the evidence of the communication, and also communication with other clients could be wiretapped. So the police would know about what she is talking about with her other clients. Wouldn't that be worth some consideration?
In this case, I think that any gathering of intelligence by police, I mean, the attorney cannot influence the way police works. He can only inform police, and the police officer can carry out these covert intelligence actions so that the fundamental rights of citizens and people are not violated. And this, a judge of court of appeal can decide on that. If the prosecutor moves and files a motion, and the operative files a motion, and then they decide. So the attorney cannot influence the way the police wiretaps. So he can inform the police, but his rights should not be violated as an attorney, and the rights of other people should not be violated. And they need to think how to make their case.
And now you have like 1 or 2 minutes for your final comment. if you would like to.
Дякую вам також.
Thank you as well.
Я сподіваюся, що це та служба,
I hope that this service indeed will start such a complicated process to restore the trust to the judiciary. One of the biggest achievements would be education if judges start writing very well motivated decisions for us to understand why the judge decided in that way, not the other way, because you need to speak not only the way that they should understand you, but only in the way that others should not fail to understand you. And I think that would be beneficial for us and for the society and for the judges.
Competition and interview. We will announce winners of the competition after 1 week, after all interviews will be over. So for now, good luck.
Дякую.
Thank you. Дуже Добрий день, пані Олександра. So we will have interview with one of the candidates for the position of disciplinary inspectors, Ms. Alexandra Lubarets. First of all, please let me introduce our commission. I'm Reda Muliene, the chair of the commission. And today also we have commission members Yulia Bokova, Olena Kovby, Olga Popikova, John Erlich, and Pavel Zelinchik. Would you have any requests regarding composition of the commission?
No.
Thank you. So our interview will last for about 60 minutes, and we will ask you some questions about your professional experience, background, and also some questions with regard to judicial ethics and integrity. At the end of the interview, you will have time to reflect and to say a few words. And also I would like to inform that probably you know that the interview is broadcasted, so if there is any kind of information which falls under restrictions for its public disclosure by the martial law, please let us know during the interview. If you do not have any questions or requests so far, so we could
Я б хотіла звернути
I would like to draw attention that I've addressed the Commission with a request with respect to the part of the interview that is about my financial integrity and my asset declaration. Given that according to the law on prevention of corruption, my declaration as the family member of the service member is not in public access, if possible, if you have any questions about property specified in the declaration, please do not broadcast this part of the interview or make it impossible to disclose information with respect to specification of this asset just purely out of security reasons. Because according to the law, the declaration is not in public access, there is no access to it, so I would like to be consistent in this respect based on the grounds that I've explained in my request to you.
So when we will have this part of the interview, and if there is a need to ask particular questions, then we will make a decision which parts or if should be closed, so the heard in closed session. So for now we could probably start the interview with other.
Yes.
Okay, thank you. So this is the time for you to introduce and to say to tell us what is your motivation, why are you here today, and what is your understanding and vision of the disciplinary inspector service. So up to 10 minutes, so the floor is yours, please.
Thank you. Good afternoon, dear Commission members. Thank you for the opportunity to participate in this competition. I'm happy that I've reached this stage of interviews because procedures were quite interesting and a bit difficult at times. With respect to my motivation, it consists of several aspects. The first aspect is that that is my work that I'm actually doing, and I've been doing it for quite a while. I believe that I do that in a competent, quality way, and I would love to continue performing this work in the future. Given that the legislation grants but special powers to inspectors like independence and independent decision making and the possibility to defend positions. For me, this is very positive, and that is a strong motivating factor for me. The second reason is quite interesting, and for me it was not decisive, but very interesting. I will explain why. As you know, I used to work in the High Qualification Commission of Judges of Ukraine for quite a long period of time. I was directly involved into the procedure of selection of judges of the newly established Supreme Court, High Anti-Corruption Court, and Appellate Chamber of the High Anti-Corruption Court. In particular, I was dealing with preparation of materials for the member of the commission to whom I was delegated as the assistant. And this is one thing when you are on that side of the screen, so to say. On the other side, thing is when you are participating in this. I would really want, and it was very interesting for me to feel this experience of the participant of the competition, because that is nerves, anxiety, increased attention of the society, and for me personally, it was sort of a challenge. I can say that. I've left my comfort zone, and of course, that is a very interesting and special experience for me. And thirdly, I would really want, of course, if I successfully pass the competition, I would really want to be involved into this new process that did not exist before, like formation of the practice, formation of the process, formation of procedures, technical aspects of work, and relationships inside the team as the newly established structure, as the new element, and I would really want to be a part of this process, because quality, effective, and efficient fulfillment of tasks and duties delegated to the service, in my personal opinion, will be able maybe restore or maybe even strengthen trust of the society in the service, because right now everyone knows about the level of attention towards the process, but it will also strengthen trust of judges. In my opinion, the Service of Disciplinary Inspectors has to be the body that will be trusted both by the society and judges. And with respect to the mission and activities of the Service of Disciplinary Inspectors, my vision about of this process coincides with the vision expressed by previous candidates. As the law sets out, the Service of Disciplinary Inspectors has to ensure fulfillment of authorities of the High Council of Justice with respect to disciplinary proceedings. At the same time, this special status of the inspector, in particular requirements to the inspector, selection procedure, which is even stricter in some instances than in case of some judges, like with respect to separate procedures. I'm not talking about all procedures, of course. This process and this status cannot be a sign that the disciplinary inspector is just the implementer. The inspector is, on the contrary, an independent, autonomous entity who conducts preliminary check, and depending on the quality, effectiveness of this check, basically the fate of the disciplinary complaint will depend. And similarly, the inspector, as emphasized before, basically consideration of the disciplinary case is a quasi-judicial procedure. That's obvious. There is the complainant, that is the prosecution party, there is the judge with respect to whom the complaint has been submitted, and there is the body which decides whether there is a disciplinary offense or not. And the inspector, if the inspector takes a decision on opening of the case and this decision is supported, the inspector is then responsible for further consideration of this issue, and the inspector represents and also has to defend own position. If the inspector insists that there is the disciplinary offense, the disciplinary chamber agrees to open the case, then the inspector has to prove, has to explain facts, circumstances, and convince. And then the judge will be defending oneself, and that is basically the adversariality of the process. The inspector has to master, has to defend own opinion, and has to convince. And there were some thoughts, maybe I have this impression, that some candidates thought that the chamber is exclusively the passive entity. It just listens and takes a decision, but I disagree a bit with that. Because if members of the disciplinary chamber have some questions or follow-up questions, they also take part in the process. Just the matter is that the disciplinary inspector has to defend own position actively with references to those facts and circumstances and materials that he or she has collected. So I believe that I'm competent, professional, I have experience, and I will be able to deal with this task. Right now that's it, and I'm ready to answer your questions.
Thank you very much for following the time and being concise. So I would like, yes, to ask you in answering questions to be as concise as possible so that we could, yes, have enough time. And speak as slow as possible just for our interpreters to be able to translate. Thank you. So now I would like to give the floor to Commission Member John Ehrlich to start this session of questions. The floor is yours.
Dobry den. As I understand it, you have also applied for head of the Service for Disciplinary Inspectors. Yes. So the questions that we'll be asking today will be focused only on your qualifications for disciplinary inspector, not on those for the head. Okay. All right, very good. So you're already within this system, and you know this system. And the preliminary question that I would have is, why do we need to change this system? Why does Ukraine have to have this service when there already is a system in place? I mean, we've got 6 people here who have devoted a lot of time. We've got assistants, we've got interpreters, we've got technical people. Why not just keep the system as it is? Why do we have to change it? Or do we have to change it?
Thank you for your question. Well, firstly, I would like to emphasize that the judicial reform, is permanent in our country. I started working in the judiciary in 2015. Back then, the reform was ongoing for some period of time, and it is still ongoing. The issue of formation of this service was raised much before 2021. When respective amendments to the law were introduced. So at some stages of discussions, these conversations were taking place long time ago. So it was not some random, abrupt decision. It was like a consistent, ongoing process. Based on my experience, I can say that there are 2 aspects, external and internal aspects. The external aspect is, of course, some distrust. I will not make anything up. I will not start saying that everything is great and everyone is trusting everyone. No, both the society and judges have expressed openly or indirectly displeasure with the work of the body. Based on my experience with respect to the internal aspect, I can say that at some point the procedure of disciplinary proceedings significantly outweighs other powers of the High Council of Justice. At some point, the High Council of Justice, given the number of complaints, will be overwhelmed, because right now we've started considering complaints. Then we get complaints against decisions. Then in case of quashing by the Supreme Court, this complaint is returned. And at some point, it all accumulates so much that the High Council of Justice will be overwhelmed. Its key task is to be the body of judicial governance, that is to ensure independence of judges. That is like a broad component, but it includes many subcomponents like financing of the judiciary, selection of judges, and other aspects. And the disciplinary proceeding takes, in my opinion, because of the disciplinary proceeding, it is very difficult to fulfill those functions which are basically the key functions to be fulfilled by the High Council of Justice. And so that is why this service has been introduced. That is how I see that, based on these 2 aspects. Thank you.
So what I'm hearing from you is that it's partly the large number of complaints that are overwhelming HCJ, and that HCJ has its other governing functions. Wouldn't it simply be easier to just hire a whole, why don't we just hire inspectors and have them work in HCJ under the current system?
It's not an really efficient system, and let me tell you why. In this case, still the member of the HCJ will be a rapporteur, so he will personally have to prepare the opinion, whatever, however many he may have the assistants, because as I understand your question, just increase the number of personnel, that's your suggestion. So regardless of how many assistants he may have, still the rapporteur will be one member of the HCJ, and he needs to process the whole scope of materials. He may ask the assistant to investigate some part of it, but still he will be the one responsible. The second point, the situation that we have today at the HCJ with so many complaints, because the HCJ was not quite effective. But this is not the first time we have the conciliation. It was first happened in 2016 when the HQCJ stopped considering claims, and the HCJ had to review all the complaints that had accumulated. And I think it was 2016, beginning of 2017, and the HCJ with the same type of story had to consider about 7,000 or 8,000 cases. And I remember one of the applicants was asked a question, why this service has to be established, and I want to say another thing here. If suddenly, out of some reason, the HCJ stops operating, like there is no quorum or no composition in place, still the procedure needs to work, because the disciplinary inspectors will be responsible for preparing the opinions for consideration. It will be ongoing. The complaints will not accumulate. They will be always in the pipeline. The opinions will continue being prepared until the HCJ resumes its operation. If there is some kind of extraordinary situation for which it had to suspend its activities, so that we have already materials prepared, so they don't get accumulated, and so that we don't have so many complaints that you need to kind of review from scratch.
You have worked as an inspector and reviewed judicial complaints. Do you see a difference, if you get this position as disciplinary inspector, do you see a difference in your role as disciplinary inspector than what you had as inspector when you were working at HCQJ?
Я хочу уточнити, я зараз...
Let me review. I'm not an inspector now, I'm a chief specialist now. This is something else.
Але якщо брати мій загальний...
But if you take my general experience into consideration, then the functions were more or less the same. Whatever you call it, inspector or chief specialist, the functions were more or less the same. As to your question, personally for me, with my current duties, there will be something new, because it will be me who would sign the opinions and bear responsibility. Let me explain what I mean. A member of the HCJ to whom I've been assigned, we have a similar understanding with him. It's really a seldom or rare case where we disagree with something. He disagrees with me or me with him. Normally we have a good tandem and we can discuss certain matters, but there are no radical, dramatic discrepancies, like disagreements, like I want to open the case, he doesn't want that. Well, it doesn't happen. We discuss everything and we always reach a certain consensus.
Попередній моїй роботі
At my previous job,
був один дуже
there was one case that I remember of.
мою позицію.
It's when my position was denied.
Я її обґрунтувала.
I provided reasons, I prepared the final decision, I suggested bringing a judge to responsibility, but this member I've been assigned to at that moment disagreed.
Особисто мене аргумент
His argument didn't persuade me personally,
і мені було важко
and it was hard for me to rewrite my personal opinion
я дотримувалася.
that I still was certain of
Готова була
and that I was prepared to defend. But since it was that role and that
окрім свого члена
duties that I had, unfortunately, I couldn't tell anyone about my disagreement except for the member that I was assigned to. So I really remember this case now, and I even remember it today,
мені було
because
приємно і
it wasn't pleasant, and I thought I was right. My position was correct one, well prepared, and was in line with the law.
And how do you think that would be different as a disciplinary inspector presenting your case before the disciplinary chamber of HCJ?
По-перше, на сьогодні
Well, first of all, the law gives the right to the disciplinary inspector, if his position is not agreed with, to submit it to the consideration of the HCJ. Secondly,
рішення приймає
the decision is made not by only one
виноситься висновок
member when the opinion is submitted to the disciplinary chamber. The decision is made not by one member but by the whole chambers. So
я коли буду відстоювати
probably when I defend my position there, someone may agree with it, someone may not, but it will be a collective decision of the body that must make these kind of decisions. If this whole body decides to deny my position, and if I'm still certain of it, I will have a chance, if everything goes well for me, I will have a chance to submit my position to the consideration of the HCJ.
як я її відстоюю.
And then much will depend on how I can I can defend it.
You used an expression about on the other side of the screen, I think, in your opening statement. I want to use that with you and ask you, if you're on the other side of the screen, if you're sitting here and you have a candidate there, and you're interviewing that candidate, what traits, what characteristics are you looking for in that candidate to fill the role of disciplinary inspector?
It's an interesting one. Thanks.
По-перше, це має бути
First of all,
має розуміти
this person must understand the situation, not just know the law generally, but know how to apply it in practical terms, because I certainly watched the interviews with other candidates, that's for sure.
деякі питання,
And there were some questions
нормально, що люди могли
when
відповісти трошки
it was alright that people could give some wrong answers, because I mean, you need to have some practical experience with that, and there are certain nuances, shades of matters, and it's okay if you don't know that. But sometimes it happened that
цього розуміння
the
роботи,
person didn't have the understanding of the job they were applying for.
якщо особа вже дійшла
Second point, if you make it to the interview stage, it means that probably you took the cognitive test and general knowledge test, you are in line with certain level. When they prepare the practical assignment, it means that they can work on this position if they scored well. And then my question would be about whether they can communicate well, express their opinion well, and whether they can defend their position.
і знаєте, що можливо
And if they have their own opinion on particular matter. That's important too. That would be my answer.
Are there any traits that a disciplinary inspector should have that you don't have?
Можливо,
Well,
передбачаючи
maybe
успішне проходження
if
конкурсу,
I'm successful
буде
in the competition,
тренуватися більше
I will need to take more training on professional debate,
я маю відстоювати свою
professional discussion, because I would need to defend my position in front of people who are professional judges, professional attorneys. I totally realize that I can't know everything. I will certainly be as much prepared as possible
до справи, до її розгляду.
for the case and for the review of the case, but still some
Стриманості.
skills of reserving myself, I mean, if the action the discussion goes really hot,
Саме от процес дебатів.
and the whole kind of debating process.
Над цим треба
Maybe this is something that I would need to work on
перед тим, як виходити
before coming out to the chambers.
You're still on this side. And you're selecting candidates, and you said you watched some of the interviews. Obviously, you have the substantive background and experience because of your work previously as an inspector. Who should compose this new service? Should we just hire all inspectors because they have that experience? Or who would you put on the service, and why would you put those people on the service?
Ну, по-перше, до етапу
Well, first of all,
дійшло не так багато.
not so many people made it to the interviews, not so many representatives of the ACJ.
Пішли професійні і достойні.
Certainly, all the candidates are professional and are really worth their name. I don't have any doubts about their professional skills.
Нова служба не має
But
складатися
the new service must not be composed only of the inspectors who have worked with the ACJ.
мали б-
As to the people who would,
мені, якщо чесно,
whom I would
окреслити певні
have in the service, well, it's really hard for me
професійні,
to
виходячи з тих кандидатів,
talk about their professional skills, but based on the candidates whom I saw, I actually selected for me a couple of people with whom, without giving you any names, but yeah, I made some note in my mind, that it would be interesting for me to work with them based on their experience, based on their understanding of the context of the disciplinary context. It would be interesting for me to work with these people effectively.
служба дисциплінарних
It's just that the SDI
один організм.
must operate as a kind of uniform body. There must be really healthy atmosphere in the collective, because there are going to be a lot of issues at the beginning, at least, and we need to be able to communicate, to cooperate, because everyone comes from different backgrounds. I've realized that based on my experience with the ACJ, in particular with complaints, I've realized that in some
Можливо, мого досвіду трошки
aspects I may lack some knowledge or some experience in some areas, and I'm trying to do as much as I can, but still. And it could be good if we could have specialists on criminal cases, because these kind of complaints are difficult, especially if we talk about investigative judges, like permits to search homes and apprehension
вони не про
permits and there are quite a few of that complaints, but they are difficult in terms of practical application of the criminal law. So if we had one person, a couple of people who have practical experience in criminal procedure, I think that would be really useful for the service.
So you've been with HQCJ or HCJ for almost 10 years now. When you started with HQCJ, how did you get your first position?
Я перед тим, як розпочати роботу
Before I started with the HQCJ, I had worked with the Ministry for Agriculture Policy
відділу правової роботи,
as a bless you, as a head of legal department. It was a civil service position, and I had worked that for a while before I applied. And
на той момент
at that point of time,
мого керівника,
my supervisor
який був моїм керівником в міністерстві,
at the ministry was given a job with the HQCJ, head of the legal service of the HQCJ back then. It was a newly established composition.
в них була реорганізація.
They reshuffled the stuff, and he was offered the position of the head of the legal department of the HQCJ.
Він мені запропонував
And he offered me
посаду перейти
the position to join him as a chief specialist. It was a civil service, and the legislation allowed
шляхом
a
переведення.
transfer.
Просто це одна посада,
So
інша
what
посада, служба
you had a kind of civil service position in one body, and then you could transfer to another body. So I was simply transferred.
Там були наявні вакансії.
There were vacancies available. That's why
Тобто мене просто
I was
перевели
just transferred
на роботу в вищу
to the
кваліфікаційну комісію.
HQCJ.
Через півтора року
Then, about 18 months later, the legal unit of the HQCJ
один з членів вищої кваліфікаційної
had this member
в нього
of the HQCJ, and his inspector took a maternity leave, and he offered me to fill up this vacancy of an inspector. At that moment, the inspector position was also a civil service position.
знову ж таки мене просто
So again, I was transferred.
потім були зміни в законі.
Then some changes took place in the legislation, and the position of inspector became a support service, so patronage service position. And since this patronage service is filled upon the request of a member, so I just continued working as an inspector, as a patronage position for the tenure of the member of the HQCJ to whom I have been assigned.
CJ, were you required, was there any competition?
No.
Okay. Have you ever participated in a competition?
Yes. Знову,
Again,
коли я працювала
when I worked with the HCJ, there was just another change in the legislation related to
запровадженням
introduction of the SDI. It was the first changes to the legislation that happened in 2021.
вже були вимоги на тому,
And there were already
як ми всі знаємо, дуже
requirements. We all know there were quite strict requirements back then.
фактично знову ж
And
змінилась структура.
basically, the whole structure at the HCJ was changed, and the position of inspectors
На певному етапі
at some
мали бути
stage
ліквідовані.
had to be liquidated.
І було оголошено
And a competition was announced to take the positions of chief specialists in the secretariat of the HCJ, and
в цьому конкурсі.
I
Була конкурсна
took part in the competition. It was a competitive-based procedure, and I passed the competition successfully, and I took position of a chief specialist, and I've been working as a chief specialist since then.
And currently you are working with Mr. Lukyanov? Okay, and he's the deputy chairman? Yes. Okay. And I want to ask you about some other people that you may have worked with. Did you work with Mr. Vasilenko?
Yes, це член вищої
Yes, that is a member of the High Qualification Commission of Judges back then. He was the only member of the HQCJ with whom I worked. Then in May of 2019, he was appointed as the member of the HCJ, and he became the member of the High Council of Justice, and he suggested to me to move together with him to work at the position of the inspector, and it was back then the support patronat service position, and I was appointed following his recommendation. Partially, I probably understand the reason for your question, because I had several members of the HCJ with whom I worked, so I will explain if you allow. So it happened because of some political situation back then that in May Andriy Vasilenko was appointed as the member of the HCJ according to the president's decree, and in June a new president came to the position and he quashed the decree on appointment of Vasilenko Andriy as the member of the HCJ. In view of these circumstances, he stopped being the member of the HCJ, but I stayed there. Back then, I worked with Ovsienko Andriy, since he was appointed as the chair of the HCJ a month later. Once I started working, he stopped considering disciplinary cases because of his position as the chair of the HCJ. So I was offered to work as an inspector with another member of the HCJ, that is Shelest Svetlana, and she had the vacant position of the inspector back then. And I worked with her until February of 2022.
Any contact with Mr. Vasilenko currently?
We do not have friendly relations, no. We can congratulate each other on birthdays, like on the lawyer's day, and that's it. That's the limit of our communication. So we had purely professional relations, and we still have them nowadays. And no personal contact with him.
Do you have any awareness, are you aware at all of Mr. Vasilenko being associated with the Maidan judges?
In what context associated with judges of Maidan?
Are you aware of his assisting any of the Maidan judges?
No. Frankly speaking, that's the first time I hear this.
All right.
Maybe can I clarify, when I worked with him, as far as I remember, even when judges were passing through qualification evaluation, we didn't have, personally, I, as the inspector, did not have any Maidan judges in my proceedings. So I cannot see any other relation or ties apart from qualification evaluation. I can't even imagine for myself what other relationship there can be. So I can't answer your question because I do not understand the context. I'm sorry. I just don't know about this.
What about Mr. Shelest? Did you work with him?
With her.
Her. I'm sorry.
Yes.
With her. Okay.
Yes, I worked with her since 2019 until February 21 of 2022.
The only judge you worked for during that time period?
Yes.
Okay. And are you aware of her having any association with Pavlo Vovk?
I understand the context of your question. In some mass media, with some frequency, there was this information published, but in the context of my work as the inspector, I did not have any connections, ties, I don't know, outside of my powers, of my authorities, or maybe if you mean whether I had some cases with respect to which she provided some instructions, no, I did not have that kind of cases. So we had purely professional relationships. I know about some information in the internet about that, but this had no relation to my work with her as the inspector.
You say you became aware of that through the internet. Was that while you're working with her or after you worked with her?
Після.
After.
So while you were working with her, you were not aware of these allegations?
No.
Additional questions, but I am going to turn this over to my colleagues for additional questioning at this time. Thank you very much.
Дякую.
Thank you. Hello, Miss Alexandra. My question will be based on you mentioning the situation when you were preparing the opinion, right? And the member of the HQCJ did not accept it, and you probably felt that it was unfair. Can you please tell me, how did you try to defend your position? Purely during the discussion, I provided references to the legislation, to the regulations, to the practice. I proved those arguments which I had, so it was purely in the form of the discussion. Let's put it that way. I did not have any other ways to convince the member. But you insisted on your position. Yes, of course, I insisted on it. It was ready completely, and I was insisting on it for sure. And as far as I understand, you remember it because right now you're recollecting it. Yes, how unfair it was. Not unfair, but I remember it. I remember the case. Was it really the situation of unfair situation? What was it about? Which aspects or values? I believed that the judge emphasized that she made a mistake. I believe that it was not a mistake, that there could be no mistake. It was not intention, but it was negligence. And the context of the situation when specific decisions were taken, in my opinion, they were unacceptable in that particular situation. And I suggested not dismissal as the sanction. My suggestion was to, maybe it was warning, yes. I don't remember the suggested sanction, but the sanction was mild. So, that's why I was touched by this situation, let's put it that way. Can you please tell me, in your previous answer, you mentioned that you worked with other employees and inspectors and members of the HCJ. Can you please tell me, how would you respond to the situation when, for example, these former supervisors of yours try to interfere with your activities? Let's imagine you start working as a disciplinary inspector and your previous direct managers start requesting or calling something or somehow else interfering. I understand your question. Interfering with activities by means of clarifying some information about some specific case, I would deny it in that, of course. Secondly, I do not keep in touch with my previous supervisors, so I don't think that I would have these calls from them. But in case something like that happens, no, for sure no. First of all, that's my responsibility and my reputation. I can't allow that. Okay, thank you. Can you please tell me, have you ever had to suggest new approaches or solutions? New approaches or solutions? Well, not that I suggested, but it was a joint position in one of the decisions that was taken recently. there was more detailed specification of the principle of proportionality. The judge was brought to disciplinary responsibility for the breach of ethical standards, but ethical conduct was not that serious as to result in dismissal. So, of course, it was done together with a member of the HCJ with whom I work. We agreed on this position, and we suggest a different wording for the principle of proportionality and its application. And my last question, can you please tell me, how do you interact with your colleagues if your vision, personal vision, regarding a solution to a problem does not correspond to their vision? If that is about cases, disciplinary cases or complaints, if they ask for my opinion with respect to some situation, I express my position. If they do not ask for my opinion about this situation, I will not try to do that, because everyone is responsible for their own task and direction of work, and I will not insist, and I will not go around saying your position is wrong, change it, because that's the interaction of between the assistant and the member of the HCJ. But if they ask for my opinion, I will share my opinion. If they do not agree with my opinion, they've asked for my opinion and not for confirmation of their opinion. Thank you. Hello, Miss Alexandra. I have the following question. In your self-presentation, you said that you would like to join the new process. Can you please tell me what is the novelty of this process? And how will the new process be different from the current process? Of course, that's about the process of consideration of complaints. First of all, there are technical aspects and there are practical working aspects. Technical aspects include correct. I understand that's more the part of responsibility of the management, but still, I, as the inspector, future inspector, if everything goes well, will be interested in access to the register of court decisions so that it would be done quickly, digital signatures, logistics of complaints like transfer, requests, scanning, the possibility to of the inspector's participation in the meeting of the chamber in the video conference mode, because so far this is not described anything, but given that the scope of work will be huge and everyone knows that, given that on Monday and Wednesdays we have meetings of chambers, on Tuesdays and Thursdays we have meetings of the HCJ. If the inspector will have to go to the building of the HCJ every day physically, my personal opinion is that it will be not reasonable a bit. So this video conference participation, in my opinion, it should be discussed at least. With respect to practical aspects of work, that is not resolution but appropriateness of assigning inspectors to chambers, just purely for optimization of work. That is maybe about approaches to work from the perspective of development of some roadmap, some algorithm of priority mandatory actions in order to simplify and optimize the work of the entire service, and so that the service works efficiently, so that the work of the service happens in a unified way. Let's put it that way. Something like that. Okay, thank you. And in continuation of Miss Yulia's question, since you've mentioned that you congratulate each other with holidays with Vasilenko, and Miss Yulia has asked this question, you've said that you do not keep in touch, and that was about previous supervisors. But can you please tell me, let's say you imagine you are appointed to the position of the disciplinary inspector, and the sitting member of the HCJ from the current composition comes to you regarding one of the disciplinary cases. And he asks either for positive or negative resolution of the case. What will you do? In a very correct manner, I will ask him to look through the draft opinion that will be submitted for consideration of the chamber according to the law. Thank you. And my last question is the following. In your opinion, from the perspective of an external observer, don't you see any concerns if you are appointed to this position? And won't you be a convenient disciplinary inspector? Let's put it that way. Convenient disciplinary inspector, my character, frankly speaking, is not very convenient in many aspects. I can say no. Just the question is whether this no will be said in a correct and tactful way or in some other form. That's it. Thank you. Hello. I will try to be concise in my questions, not to take too much time. Given your previous experience, why do we have so many complaints against judges? What is the reason for that? My personal opinion is that it is related to the publicity of the judiciary in the past, that it became so public. Let's be honest. Right now, some judges, some courts are like very notorious. They have become very notorious. Like 10-15 years ago, it did not exist at all. But this is related firstly to this publicity that has been given to the judiciary and which did not exist in the past. People became aware, more aware, and maybe the possibility to submit a disciplinary complaint has become quite a prevalent phenomenon. If previously mostly lawyers knew about that because they were working in the judiciary, but now everyone knows about courts, judiciary, their functioning, just like people who do not like, for example, the position of the judge or conduct of the judge. The first thing they do is submit a disciplinary complaint, even without any intention. It's like, I'm not saying that it's a large-scale phenomenon, but exists just because they are insulted, just to express that they are displeased. That's one moment. And the second moment is the fact of the possibility of consideration and publicity of the High Council of Justice, which is very public, and the entire judiciary as well is very public. And I think all of this has significantly impacted the process. Thank you. The right of the judge to challenge decisions of the chamber regarding bringing to responsibility is undeniable. Does the complainant have this right? For example, if the complainant disagrees with the decision of the chamber, the complainant can challenge the decision of the chamber only if the chamber provides this opportunity. The chamber provides this opportunity, and this is set out by the rules of procedure of the HCJ, in particular if the decision was taken not unanimously. And what if the decision is taken unanimously? As a rule, they do not give this opportunity, but they can give. So that is the discretionary power of the chamber, right? Yes. In any case, the chamber can grant this right. Not in any case. Why? Why not? Why not in every case? If there are some specific... No, not contradiction. If the decision is taken not unanimously, then this right can be given to the complainant. I hope that you know about the practice of our disciplinary chamber in particular, even when the decision is taken unanimously, the chamber still gives this right to the complainant. Yes, but that is not prevalent, but that is not prevalent. But we will understand that this discretionary power exists. Yes, of course. Okay, can you please tell me, I will go back to your supervisors with whom you worked. Are they sitting judges right now? No. No. So all the surnames that have been mentioned before, members of the HCJ with whom you worked, are not sitting judges right now.
Суддями було виключно два члени.
There are only two members of the SCJ who are sitting judges, but as of today they are retired. They are not judges any longer. So we can understand it as follows: that if you are appointed, there will be no conflict of interest on your side because they are not judges, and as a result, the complaints against your previous supervisors, that won't happen. Okay. And the last question. Let's imagine a following situation, and please tell us what do you think of it. You are a chief specialist. You are drafting materials, files about a disciplinary complaint. You have a friend. She also is a chief specialist, but with another member of the disciplinary chambers, like myself, for example. And your friend comes up to you with a question, asking to provide information about the possibility of review of a certain complaint that you are preparing. For example, whether it's going to be denied or granted, it's going to be initiated or not. Do you see any ethical dilemma in this situation? Yes or not? If yes, what are you going to do?
Якщо це стосується конкретно
If it is related to a specific just no, it's not we're not talking about lawful position. No, we're talking they are asking you about a particular case. What are you going to do about it? And
я ще її не готова.
well, I haven't considered it yet. I have not drafted it yet. That's my answer. Is there a dilemma here? Certainly there is. Okay.
Thank you. I'm looking at the time, so I will probably limit myself to one question. You have substantial experience working with the High Qualification Commission and the High Council of Justice, and you were working and still working through those times, turbulent times, let's say. I see that in High Qualification Commission you were working in 2016 and then 17. Those were times when new qualification assessment system of judges was introduced, which was faced by judges but met with judges with quite resistance and also other things. Have you ever been approached by someone, candidate to judicial position, or a judge who is under this qualification assessment, or in other situations by some people with, kind requests, either beyond already the line of ethics, or on some, just to provide, for example, information, which is information, but at the same time maybe too much. So have you ever had those situations in your professional life?
В мене була одна
I've had one situation when I worked with the HQCJ during the qualification assessment, and I approached the law enforcement agency with a request to identify an object that can amount to an illegal benefit. I had that kind of situation. How?
Воно нічим не вирішилося.
Well, there was no result. I approached the law enforcement agencies according to the law. I informed my supervisor about it.
Відповідно до процедури була
According to the procedure, there was a certain statement prepared.
мене викликали на
I was asked to go to the investigator for an interview. The HQCJ was visited by NABU staff, but I wasn't interviewed with a protocol written down, prepared for that. So it basically led to nothing.
This action was met and perceived by colleagues in the High Qualification Commission, either other specialists and inspectors, or members of the High Qualification Commission, because I think that people got aware about this action inside the institution?
Це не було темою обговорення.
Well, it
всієї
wasn't
комісії.
discussed by the
Можливо, десь
whole
хтось,
composition of the commission.
умовно кажучи,
Maybe someone somewhere there discussed some rumors somewhere aside, but asking you questions, why did you do that or something? No one asked me that.
звичайно, члени Вищої комісії,
Certainly, the members of the HQCJ were aware of it because the judge against
через якого ви
or because of whom the situation occurred, he was undergoing the qualification assessment at that time.
можливо, це буде так дуже
And
помилково сказано.
maybe I'm
Пальцем в мене ніхто не тикав.
gonna say it in really straightforward form, but no one poked fingers at me.
Is up, but if you allow me, I would like to have some questions even in the first part, because we are still in the first part, right? May I? Okay. I will try to go very fast because of the time. And the first one maybe will surprise you, maybe not. You worked for both HCJ and QCJ. When this reform will be successfully implemented and the burden on the shoulders of HCJ members will be partially transferred to inspectors, do you think that the competencies of HQCJ and HCJ can be merged into one body?
Коли ситуація стає
When the situation is stable, yes.
Thank you. What do you mean by stable?
як мінімум, коли
At
завершиться
least
реформа,
when the judicial reform is over, in particular the qualification assessment of judges.
Okay. You already know what I'm going to ask. Which is, you said that the judicial reform is an ongoing process. How can it be over? And no, that's not the real question. The real question is this. The real question is this. Why do you think it such a complicated process, such a, I even heard from one Ukrainian academic which compared the Ukrainian judicial reform to a Brownian motion from physics, to motion of particles without clear direction. Why do you think is the judicial reform so complex, complicated, challenging? Please tell me one or two major reasons which you perceive as the most important.
Коли почалася реформа,
When the reform started,
були певні маркери,
there were certain
очікування,
expectations, markers, let's say,
сказати, що вона завершена.
that could be used to indicate that it is over.
Не
Yeah.
стало.
But it never happened for certain reasons.
Оскільки наслідків не настало,
Since
значить,
it didn't
повинно
happen,
бути
so maybe something was done wrong. So let's check over, let's see what has been done,
результат має
because the result should be in place, but it isn't
з певних якихось
for some
не
reasons.
досягли цей спосіб,
So we didn't achieve it this way, okay, let's try it this way.
там, не змогли досягти
We
цей
failed this way, let's try another way.
Це моя така
That's my
думка,
opinion.
виходячи з контексту.
Given the context.
But I didn't hear the reasons why we didn't achieve those markers.
Можливо,
Maybe.
не, певним фактором, не основним, але він є. Це
Not the most important factor, but still it is in place, is the resistance of the whole of the system itself.
деякі обставини
You can't rule it out, and some circumstances and situations related to the qualifications assessment that still continue today kind of confirm this point.
можливо,
Second point
недостатність досвіду.
may be a lack of
Оскільки,
experience,
як ми бачимо,
because
майже
as
всі
we see,
таких важливих процедур
all such
залучаються
important
міжнародні
processes involve international experts.
І, можливо, не співпадіння
And maybe some mismatch
нашого національного
between our national
бачення, можна так сказати,
vision, I would say,
баченням
with the
міжнародних експертів.
vision or with understanding of international experts.
Оскільки важливо знайти той
Because
тандем,
it's
який
important
би
to
запрацював.
establish this tandem that would really work. Now, partially it does, partially it doesn't, and we are trying to do as much as we can.
And the last question. When you said resistance of the system itself, have you been aware of the signs of such resistance while you were working in these two commissions?
Ну, деякі події були
Well,
настільки
some of
очевидними,
the
що
events were so
неможливо
obvious
було
that you could not know about
Can
it.
you please tell me three types of such resistance which you experienced yourself or was aware of from the first-hand experience?
Коли судді не приходили на кваліфікаційну
When judges didn't show up at the qualification assessment,
підряд.
a couple of times in a row.
Okay. And then?
Ем, те, з чим я стикалася,
What I
особисто,
faced
коли
personally
проходила кваліфікаційну
when I
підготовку,
carried out qualification
були
assessment,
певні ситуації,
well, there were
коли
certain situations
судді
when
йшли на кваліфікаційне
judges
оцінювання
went to be
вже агресивно.
assessed at this qualification assessment,
Агресивно не зовсім те слово,
well, not kind of being
налаштовані до
with aggressive attitude, but they were negative about the whole process and about the members of the HQCJ. And that was clear, evident. It's one thing when a judge kind of contributes to his assessment, facilitates it, and that is done in a convenient environment.
That's all.
Thank you. No more questions? Oh, so yes, now.
I just have one follow-up question, and then we'll briefly touch on property integrity. I think the question was why you think there is public distrust in the judiciary, and you responded and said that there are some of it is the media and publicity. My question is how prevalent or how pervasive do you think actual ethical misconduct is among judges or the judiciary in Ukraine? In other words, is this a problem of just reporting, or is this a problem of actual underlying problems that are being reported by the media?
Мабуть, правильніше буде сказати,
I think both, I would say,
певний період
to some extent.
часу,
On the one hand,
масово
at some point of
почалося
time,
дуже сильне висвітлення
there was
принципів діяльності
a massive coverage of the judiciary activities started that never had happened before.
І, звичайно ж,
And of
таке
course,
масове
that kind
висвітлення,
of massive coverage
спричинили не якісь позитивні
came about not because of some positive developments. There were some
певних суддів,
actions committed by certain judges that
таке, таку ситуацію.
led to that
А,
kind of situation.
І так, як це, знаєте, це як пішло, як
And it
цепна реакція.
started like a chain reaction, I would say.
Один, потім другий,
So one thing, the next thing, the next.
почалася дуже прискіплива
So
робота.
there was an attention
Певний
paid
момент
to
кожен
details, and at some point of time, every such case was covered, and those actions were
це
negative.
було безпідставно.
I can't say there were no grounds for that. Certainly there were.
Є висвітлення.
And yes, there was coverage. It was brought to the attention of the public, and it played its positive role in this.
Ну, як показує
In this regard, because
що,
as we
деякі
see,
вчинки
some of the
були припинені.
actions stopped at some point.
Ну, це є невід'ємною частиною
But this
діяльності
is an integral part of the activity of the judiciary.
не тільки служби,
But
але й
the objective of the service and the ACJ and the HQCJ
побудувати
is to
систему
build
судоустрою,
the judiciary system in that way
не,
that
по-перше, не толерувати
doesn't tolerate that kind of actions at all, and so that such actions are not committed at all, because there will be 100% responsibility for that.
So, thank you for answering all of our questions on the competency issue. With respect to the property integrity, we and our assistants in particular sent you a number of questions. They dealt mostly with real estate, real property, some involving cars. You have responded to all of those questions regarding residential building ownership and land plots. Those questions have been answered to my satisfaction, that I do not need to ask any additional questions, but I will ask the panel, the commission members, if they have any follow-up questions on those issues. All right. I'll turn it back to Madam Chair then. Thank you. Dziękuję.
Small question, right?
Small question to the first part.
Okay.
Thank you. I will go back to the very interesting discussion about resistance from the system. And I will try to ask a very important question for my understanding of the judicial reform in Ukraine. You were there throughout the years of the reform. You were working with various people. And we already mentioned some of the types of the resistance the system used to somehow deal with the reform. Have you ever experienced in your place a situation when you would find yourself in a tension between, for example, the opinion of your supervisor, whoever it was, I am not going to use names, your supervisor, and his approach to issues related to judicial reform, and your own approach with regard to judicial reforms throughout the last 10 years, a tension which would be significant. I really disagree with this opinion action of my supervisor with regard to the important development we are talking about.
Я такого не пригадую.
I can't remember anything of that kind. Certainly we had discussions, we
Емоційні,
had emotional
але прям щоб
discussions,
категорично ми
but if you're
зійшлися
kind of radically
в певних протилежних
in disagreement,
ну,
we had some absolutely opposing views. No, I mean, there was a point of view, it is well argumented, and it has the right to exist. There is, on the other hand, my own opinion. It is also has some argument behind it, and it also has right to exist. This is the discussion, and the discussion lead to the truth.
розсваритися.
But, I mean, it never happened when we totally unfriended ourselves.
Wasn't your role to navigate the reform or the steps of your supervisors, but you were right. Some media reported on some, from the outsider's perspective, quite serious allegations against some of your supervisors. So outside of your discussion about your work and the operation of the unit, when you see the public perspective, would you say something about agreement, disagreement? Along those lines, I already asked. When you see the actions of supervisors who you worked with and the public information, was there any tension you found yourself with regard to their actions with regard to judicial reform, please?
Well, what a question you are asking. Let's put it that way. Information about Andrei Vasilenko. For example, I heard it for the first time today, and it was news for me. Frankly speaking, I've never encountered that. And in our work, it was not raised, mentioned in our work. With respect to, again, I'm a lawyer. Just existence of some information, I'm very critical about information in the internet, sources of information, etc. Just to write something in the internet and, roughly speaking, send it to some anonymous Telegram channel, that's one story. First of all, I'm the lawyer. I have to use facts and data. If there is information like that, it should be somehow, in order to influence my decision or attitude, it has to be either be confirmed in some way or it should somehow influence my work, I don't know. Like, roughly speaking, for example, some instructions with respect to which make me feel uncomfortable. That's a completely different situation. Then the conversation will be different. When just like, look, here it's information about the member of the HCJ with whom you work, like see that in the internet, that is like a very evaluative category.
No more questions. Okay. So thank you very much for your participation in the competition and in this interview. And now you have some time for your final words if you would like to.
Thank you. Thank you for this opportunity to participate in this competition. I would like to express my gratitude to the Commission regardless of the result. Of course, I would love to win in this competition, but that's up for you to decide. I would like to express my gratitude, first of all, for a very pleasant atmosphere of the interview. Some questions were, frankly speaking, not convenient. Some questions were unexpected, but still I have a very positive impression from the interview and competition, and thank you.
We will announce results of the competition after 1 week. So thanks and good luck to you. Thank you.
Дякую.
Добрий день, пан Станіслав. So, this afternoon we will have an interview with one of the candidates for the position of disciplinary inspector, Mr. Stanislav Grishin. So, first of all, I would like to introduce our commission, which is in its entire composition today. So, I'm Rada Moliene, the chair of the commission. The members of the commission are as follows: Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Would you have any requests regarding composition of the commission?
Відсутні.
No requests.
Our interview will last for about 1 hour, and we will be asking you some questions regarding your professional experiences, background, competences, and also ethics and integrity. At the end of the interview, you will have several minutes for your final comments. Right. And also, I would like to inform you, of course you know it, but this is the technical detail that the interview is broadcasted, and if you have any information which falls under restrictions for its public disclosure under the martial law, please inform the Commission accordingly when this particular part of the interview comes, and we will then decide on having it in closed session. If you don't have any questions or requests so far, so we could start our interview.
Щодо запитання, хотів повідомити.
I want to inform that I was a serviceman, and I'm ready to generally describe what I was involved in, and with regard to certain defense industry issues I can describe in general, but if there will be a request from the committee, I can share within the limits of closed interview. I'm ready to describe it in general terms.
Specific questions, then we will decide separately. Okay, so then we could start from your introductory presentation about your motivation and about your vision, how you envisage this service, and your some professional background. The floor is yours.
Доброго дня.
Good day, dear committee. It's a great honor for me. I'm lucky that committee is my interview is after lunch. According statistics, after lunch hours they're more lucky. I want to inform you that my professional career started back when I was a student. When I was studying in Yaroslav the Wise Law University, I was already part-time working as the lawyer in law firm, as assistant to lawyer in law firm. And when I was a student, there were certain events that outlined my further life. I'm talking about revolution of dignity. I didn't stay beside that events. I directly participated in the events of revolution of dignity, both in Kharkiv and in my native city Zaporizhia. Zaporizhia, it's a city of Cossacks' glory and knightship, and so at the same time it's an industrial city industrial catastrophe, and it's unique situation that among all eastern Ukrainian cities we had most largest protests, which I also participated, and they reached apogee on 26th of January 2014. We had the largest meeting at that day. I was there with my family, with my brother, with my mom, and it was very cold, and we went back home, and as soon as we left, there happened forced
attack on the protesters. Symbolically, police did it together with so-called titushki. This is Ukrainian term for able-bodied men who acted together with law enforcement persons. And at that time, we free of charge, we provide legal assistance to the protesters who later applied with court claims, and until this time I remember all the 3 days of those events. Me and my brother, we were not eating nor sleeping. We were moving around different imprisonment detention centers. We talked to investigators. On the 3rd day there were proceedings what was characteristic for the Zaporizhia, and to 0 of the protesters. The judges announced verdict of detention. Either they announced home arrest or even less serious sanctions. I remember that moment. I triumphed, and we were also praised by numerous civil society organizations, Helsinki Human Rights Union, and I felt big success. And also when I was on the first year of law university, I was selected to study to receive double law diploma with the University of Juris Emeritus in Lithuania, and my studying in the European University changed my mindset even more. I understood the principles of true academic democracy, respect to the students. I felt on other side very strong requirements to the students academically wise, and I also won the grant according to Erasmus program, and I studied in the University of Vienna for 1 semester, and after that I returned to Zaporizhia and I was writing my thesis for master's thesis, and I also started in parallel very active practice of a lawyer. And in my view, my practice is quite unique because I participated in all types of jurisdictions: civil, criminal, administrative, economy, law, constitutional law. I'm constantly lived on the road. We have such a proverb that lawyer gets his bread from his legs. So I was constantly participating in procedural cases. For me, it was very often that I started work in a court session in Zaporizhia court and ended with some investigative actions in the oblast in Mariupol. So for me, it was important in the cases where I participated, I would prepare legal positions within the case on merits, and then my thoughts, sentences, my legal thoughts would enter to the resolutions of the Supreme Court, and to win in a Court of Cassation, that was already a success. And another post-victory is like when after 2 weeks or in a month, we had a public communication of the Supreme Court that would mention my sentences in the resolution of the Supreme Court. So with the judges of Supreme Court, they quoting my decisions. They use these are very numerous claims: inheritance, taxation, criminal proceedings. There is certain issue to this. I can general legal practice, bankruptcy, counteracting raiding attempts, criminal practices. I can say that initially I wasn't involved in that, but due to the large amount of challenges, I started practice in criminal process. Mostly, I'm talking about protection of victims. I think that protection of victims is one of the most difficult forms of legal activity in Ukraine. It's very important to defend victims and prosecute those who are suspected. And I was also preselected for the program Lawyer of the Future, and this program was financed by governments of Canada and Embassy of United States. And again, it changed my mindset, because this was incredibly powerful program of development of lawyers. We were not taught hard skills, that's when I learned about such terms, hard skill and soft skill. But we were reprogrammed in our soft skills. I'm talking about communication, self-presentation, how to interact with client, how to interact with court, how to prepare your speech, introductory or conclusion, how to get prepared to questioning of witnesses, how to interact with mass media. Another thing, what maybe why I'm ended up here, another term that is environmental thinking. It means like environmental thinking is when you think not only about yourself or limited circle of people, but you're thinking about profession, about community, you're thinking about world that is around you. And after the program Lawyer of the Future, I was selected to the Commission of Attestation of Local Prosecutors. This was my public volunteer work. I was assessing prosecutors on how they adhere to the professional ethics standards. That was quite a big challenge, which I think I coped with successfully. There were a lot of innovations that I practiced during that event. I am very proud of our decisions. I am proud of our committees, and when I'm revising decisions that we prepared based on how they were later evaluated by court bodies, most of the decisions were proven in courts. In 2021, I continued my activities as lawyer. I did a lot of pro bono cases, mostly to military servicemen, those who are veterans of anti-terrorist operation, combatants, and groups who needed help, and mostly they required my participation as a representative of a victim, and I always undertook such cases and finished them. Just to finalize my thought, when the full-scale invasion started, everything was changed to before and after. I mobilized. I undertook quite a significant role to implement important defense project within the operational sector Zaporizhia. I received acknowledgement from the general staff. Then after that, my assignment was finished based on the resolution of the Commander-in-Chief of Armed Forces, and then I returned to Kyiv, and I find myself another place where I can service. It's a state logistics operator, newly established state enterprise on procurement, on public procurements. So that's a absolutely new institution with integrity, which it can teach a lot. Service of Disciplinary Inspectors, and finally I'm here at the interview to the Service of Disciplinary Inspectors. It's a professional challenge for me, and returning to the issue of environmental thinking, I think that lawyer is important profession, but to the certain extent you're opposing your legal opponent to a state. But now I cannot be opponent to the state. I cannot do this currently at current situation. I think that all people with professional business qualities, they must serve the state. This is for me, it's about mission, about service. Together with a team, we can change a lot in disciplinary proceedings. We can introduce quality changes, not a cosmetic repairs, but total overhaul of the judicial system to prove the cleansing of judiciary. So like two things that pushed me to submit documents for the competition. Because I'm from Zaporizhia, and from Zaporizhia Oblast, which is to the major extent is occupied unfortunately now, I participated in cases of judges who now turned into enemy, who violated their oaths. I must admit that these judges had no right to administer justice even before the full-scale invasions. With regards to number of judges, I personally submitted complaints to the High Council of Justice and High Qualification Commission of Judges. Unfortunately, those complaints were not considered, and I think at that time that was a mistake, because these were a high quality prepared complaints, and this was my first emotional intention to submit documents. And reason number two is my 6-year daughter, who says that she wants to be a lawyer as her father, and I want that in 20 years she would enter totally different judicial system, not the judicial system where I was starting my career, for the system to be on par with the best European jurisdictions. Thank you, colleagues.
Our commission member, Olga Popikova, she will start the session of questions. Olga, the floor is yours.
Доброго дня, я вітаю вас.
Greetings at the interview. You have very interesting self-presentation, and as I understand, you have quite versatile professional experience, which you now shared with us. Thank you for that. And I want to say that when you say that we need quality changes that you deem necessary, and when that it's your main motivation to submit your candidacy, I want to ask your opinion about what current difficulties, challenges you see in the activity of in disciplinary proceedings that is now performed by HCJ members. How now discipline chambers are functioning. It's a great change comparing what was happening before the reform. So this is big jump ahead. With regards to what, in my humble opinion, what can be improved, of course, timelines of consideration. In majority of cases, when I submitted complaints, they were not considered even in 2 years, because a judge was dismissed, or the deadline for complaint already expired, or for some other issues. One of my positions is that we always must think how to optimize procedures. My managerial experience is based on always trying to optimize procedures when it's possible. I will give a practical example. At certain time, I was attentively listening to the competition to the Supreme Court, and every interview within the competition or qualification assessment, there were like 15 minutes of the rapporteur who was presenting judge's case. But if now here we see the work of the Competition Commission of SDI, that when starts interview immediately, and now when I watching the broadcasting of the disciplinary chambers, and there are some issues like when the complainant didn't come, judge didn't came, so we can optimize those hearings and sessions. For example, we had practice when prosecutor, when during the preparation case, they were forced to read out the prosecution act, and that would made it impossible.
Thank you. Unfortunately, we are a bit limited in time. You are very interesting, of course. I'm grateful for the compliment to the members of the HCJ and the Selection Commission. It's always pleasant to hear that. At the same time, can you please tell me, in your opinion, the principle of patriotism is the same as integrity or not? That's a difficult question, and maybe not even legal one, but more of a philosophical nature. Integrity is a very complicated legal, social, and moral category. It includes many elements. And of course, there was a discussion in the Commission that is about sustainability. It is a sustainable category. You cannot change this balance all the time. I believe that patriotism is an integral element of integrity. For me, going back to the statement about ecological thinking, I like the quote of Ayn Rand, American writer, that if a good person does not sacrifice and does not do anything, then it is not a good person, that is just opportunist. And I'm absolutely convinced that integrity means that you have to do some actions, some deeds. And that is my position. And patriotism is not the passive category as well. A person who is patriotic has to confirm that with some actions and some genuine active deeds. Thank you for your answer. I have the following question to you. Now, there is a very lively discussion about indicators for evaluation of integrity and professional ethics of judges and candidates for judicial offices. In particular, I would like to hear your opinion that during evaluation of integrity, family members are also considered. And it is established whether these family members acted in line with the legislation and refrained from actions which can undermine the authority of justice or decrease the level of public trust in the judiciary. What is your opinion that family members are also subject to this evaluation? That is a difficult question. That is controversial. It borders with the principle of personalization of legal responsibility, that the person is responsible for own actions. And the principle that family members are evaluated logically is based on bungalow principles. They also mention family members. So yes, really. Taking into account international principles, we cannot ignore this. But at the same time, I believe that this should not be the decisive factor, the final verdict with respect to the person. For example, during military service, I know service members, I know people who have very difficult family situation, and basically these are life dramas when their family comes from Donetsk region and one child is the defender of Ukraine and the other child is fighting for Donetsk People's Republic or something like that. And with respect to these service members who are fighting, for Ukraine who have not betrayed their oath, who are Ukrainians, they fulfill their constitutional duty in a competent way. In general, these are very difficult questions, especially when we're talking about the martial law period. Even this name, martial law period, it sets out that morality and internal values and legal provisions change, and there are the other principles of law application. And I think all of this should be taken into account during evaluation. Thank you. I've heard your answer, Mr. Stanislav. Now I would like to ask you a question while trying to take into account the martial law period. Can you please tell us, since 2023 or 2022 you have served in the armed forces of Ukraine? I was mobilized since October of 2022. During the period from April of 2022 until October of 2022, I fulfilled specific tasks, initially as a volunteer and later on as a volunteer of the Territorial Defense Unit in Zaporizhia. Actually, I was waiting for the possibility for recruitment and mobilization to the place where I wanted to go and where they were waiting for me. And finally, it happened. So right now, you are the attorney of the state-owned enterprise, yes? No. Given that we have limited time, once I was fulfilling the defense reform within the framework of that enterprise for 6 months, I was transferred to another battalion that is dealing with unmanned aerial vehicles, a very powerful unit, absolutely amazing unit. And again, given that we have some restrictions, I cannot provide you with facts and examples. And right now, I've been released from military service due to family circumstances. Right now, I'm a civilian. But in 2023, you were the service member. And you also declared income from entrepreneurial activities, emphasizing that you were the service member and it was not restriction for your entrepreneurial activities. What was the status? What do you mean by the status? Were you the officer? I was a sergeant. Okay. So, there are no restrictions with respect to entrepreneurial activities. No, I was not the official in the military in the understanding of the law on corruption prevention, taking into account explanations of the NACP and regarding financial integrity, as I've explained in my answers about this. Thank you. My last question to you is the following. I'm trying to phrase it in a correct way as well, but all commission members have your explanations, and you will understand that. Okay, enterprise that is producing and supplying drones produced in Ukraine repeatedly participated in different tenders, right? Don't you think that in particular, in tenders for procurement of drones by the Zaporizhia administration, don't you think that these were successful tenders for this enterprise? And your brother was also the deputy of Zaporizhia Council? No, absolutely no. I think that it would be correct if I could answer this question in detail in the closed part of the interview, because there are some issues relating to defense procurements. Okay, so you've highlighted that in your explanations that you've provided to us. You've provided examples of not very successful issues as well, I mean tenders. Colleagues, do we have the necessity to close the interview about this, or will we just use the provided explanations?
At the moment we can proceed further, and if you come back and we feel that we have to ask some particular questions, then we will do this. Okay? Good.
Дозвольте, я можу
I can say that this is a very small percentage of our contracts. I can't during the closed part of the interview, I can explain how this happens, with whom contracts are concluded, and how this works in general. So that is my explanation now. Okay, thank you. Colleagues, that's it from me for now. Hello, Mr. Stanislav. I have a following question. Can you please tell me what does it mean to you to submit a disciplinary complaint? Why is it needed? You've mentioned that as attorney you submitted disciplinary complaints. Were these some scandalous conduct instances by judges, or what was that? So there is the procedure of challenging the decision in the Court of Appeal if the party disagrees with the court decision, and there is the procedure of submission of the disciplinary complaints. So for you, what is it? Why do we need disciplinary complaints? What is the nature of the complaint? All of the complaints that I've submitted, or in collaboration with other attorneys, if we submitted that together, I'm ready to explain and to sign each of these disciplinary complaints in blood. I am personally deeply convinced that these were so scandalous instances that could not be ignored. I can provide examples when I submitted disciplinary complaints. Maybe I will start from this instance when we managed to bring the judge to disciplinary responsibility. It was a civil case. I was the attorney for the client, so-called credits of 2008, when there was the assignment claim, factoring agreements, etc. And someone bought this debt. He had no documents. He went initially to courts with correct territorial jurisdiction, and ultimately his claim was rejected because the court established all of that. We identified that 6 months later, an identical decision was adopted in Kharkiv region. So they used the scheme with artificial guarantee, and they adopted the respective decision, but that was not the essence of the violation. Since it was in absentia decision and there were requirements from the Civil Procedure Code, we had to submit an application on revision of the absentia decision, and the court did not review it, did not consider our complaint. And that decision was enforced. It was subject to enforcement. We submitted the appellate complaint. Back then, the requirement of the procedural legislation was that the appellate complaint had to be submitted through the first instance court. So the court accepted this appellate complaint and did nothing with it. And we sent a message to the Court of Appeal so that it would take measures in order to request this case. The court denied in that. And of course, the decision was quashed by the Court of Appeal with powerful and statements regarding violations of the first instance court. I even forgot about submission of the appellate complaint. 2 years later, at the website of the HCJ, which I monitor on a regular basis, I found that the judge was brought to disciplinary responsibility in the form of a warning. She said that she was very busy, that she had excessive workload, she did not have time to review the in absentia decision. She admitted her fault, and it was caused purely by negligence, that she was just overloaded with work, and accordingly the High Council of Justice brought her to disciplinary responsibility in the form of a warning. And that was the only successful example. Other examples include, for example, while defending interests of my client, there was arrest on property, and the court of the first instance quashed arrest of property without any justification. And the ruling on this cancellation, according to Article 174 of the CPC, was not challenged in the Court of Appeal, but the victim actually he had no sense to fight for. He had nothing to fight for in this case, because the only possible satisfaction in the form of collection of damages was actually lost. And instances with respect to those judges that I've mentioned on the occupied territories, and those were scandalous situations. I was a young lawyer coming to the court hearing, and I'm sorry, the judge was smoking in the room. She was without the robe, without anything, and like she is starting the process. And I make her like comment that we have a court hearing, we have the civil procedure code. Of course, everything was stopped. She put on the robe, she put on the insignia of a judge, and like absolutely scandalous rulings on interim measures under the claim to arrest property, to suspend works on the land plot. Everything was quashed by the Court of Appeal later on. But later on, I also checked information about her in the Register of Declarations, and back then the e-declaring was barely launched, and all judges were submitting declarations, and this judge did not submit her declaration. And I sent complaints to the HCJ with respect to the fact that there was no declaration as well. I sent complaints to the NECP, NABU, and the only body that responded to my message was the Division of the Police in Zaporizhia region, and they prepared the administrative protocol regarding this judge, which was closed due to expiration of terms in the nearby court. And of course, the judge submitted her declaration after that, but in my opinion, there were obvious signs of disciplinary offense. And I do not know why the High Council of Justice back then took no measures to bring this judge to responsibility when there were obvious signs of the offenses. Thank you. So please tell me, I have a question. What is the meaning for submission of disciplinary complaints? Only to punish the judge? No, that is not about punishment of judges. That is about ecological thinking. Maybe I have the heightened sense of fairness, but I'm completely convinced that every attorney, every lawyer can change this reality around us. And this way, the disciplinary complaint in its essence has the word discipline. And that is about increasing the quality of justice that is happening around you. Okay, my next question is also a short one. Can you please tell me? For example, you are appointed as the disciplinary inspector. You start working, you get a complaint. You get a complaint against actions of a judge. For example, the decision was legal but not fair. So the decision of this judge was taken according to the law, but the society believes that it was not fair. And the society, for example, starts posting something in the social media, they start putting pressure on the inspector as well. And what are your actions in this case scenario? And one more follow-up question to this question. So there is also the public opinion, and there is, for example, like ordered actions upon request. How can we distinguish this public opinion from these ordered actions upon request? What are your actions? Thank you for your question. Actually, that is a very deep question which we can discuss. There is an ongoing discussion about public outcry as a ground for the disciplinary proceeding being included in the case of priority cases, but of course that is up for evaluation. I have quite significant experience about under cases on protection of dignity, and I've won all of the cases in this category. And the most recent case law, including the one of the European Court of Human Rights, shows that even subjective opinion can have factual support. In case of public outcry, I'm convinced that you can study specific facts. For example, there is a white newsletter published by civil society organizations about media with integrity. That is, the mass media which comply with journalism ethics, which check information, which verify their sources of information. These are like national mass media, like, for example, Ukrainian Pravda, Дзеркало Тижня, Liga, and many other. And for example, there are also anti-corruption investigations, which can also cause significant public outcry, and they are trusted by the society as well. I'm convinced that if a specific event is covered by these national media, which are trusted by the society and national institutions, then this proceeding can be included into the category of those which cause public outcry. Yes, personally, I've dealt with that a lot when there are some artificial messages through some network of half-fake accounts in the social media. And basically, the investigator has to be able to distinguish between real facts and fake accounts, fake news, fake communication, etc. I have experience within the framework of the military service, and I have this experience of working with open source investigations. I know which templates, how to do that, and I know how it can help to create the capable service of disciplinary inspectors. So I believe that it is possible to develop some universal categories which will be fair for everyone equally. Thank you.
Greetings, Mr. Stanislav. I have following questions. You mentioned that you're aspiring to build up a new judicial system. What's wrong with current system? How you personally can influence on that, being a disciplinary inspector?
Яку я бачу?
Mission, my first personal mission that I see for myself, and I announced during my interview, that Ukrainian judicial system should have no judges with foreign citizenship who took the enemy's side. Of course, High Council of Justice did a lot on that matter, and my mission will be to ensure that we checked everything, all sources that are available, and 100% ensures this mission, not like 93, 97, but 100%. We assure that we don't have a person who can question the whole system. When we were assessing prosecutors, and I had this Templier attitude. Just give me an opportunity to finish my thought. For me, the insight and paradox was that absolute number of prosecutors who came for reattestations, they have integrity, they're adequate, and they at high quality level performing their job duties. And the critical small amount of people with low trust and actions of which are extended to the whole service, and when service is perceived negatively. I'm sure that judicial system in Ukraine, it has its quality, but it has its own problems. But our work will be to surgically find such issues and adequately react to them. If I understand you correctly, if we fire all judges who are traitors, the trust to judiciary will raise, and this will be a major change. Yeah, to a certain extent, I think it's not, the logic is not quite there. It's only one of the tasks that we have to achieve. And in my opinion, this is about proper communication with the society, that High Council of Justice can announce to public, we did everything. There are no one else left. And this would will be an adequate position, quite constructive one. I look this issue what I was interested in. Who is the subject of complaints on such judges? This is police. I saw complaints from prosecutor's office, certain departments of state security service. I saw requests from public activists, and I, as a citizen with the legal education, who cares? And I'm thinking, which body gives leadership? Who wants to solve this problem, these tasks? I understand that High Council of Justice can be complainant and do the proceedings, but I'm deeply convinced that as SDI we can be leaders on that process. As of today, there are authorities, according to the law on High Council of Justice, that by the initiative of the disciplinary chamber, a proceeding can be opened that potentially SDI can do a lot of research on that matter and suggest to relevant chambers to initiate certain proceedings. Research on what? There is high quality programs. There is a high quality software with which I worked when I was a serviceman that can help with solving that issues. Can you outline the problem and the subject of research? The subject of research is to find out certain documents or other documents or data that can testify that person who was a judge of Ukraine now is administering justice on behalf of other state without can we do this without disciplinary complaint? This is a discussable issue. As of now, we cannot do that outside the disciplinary proceeding. Of course, I'm talking about availability of certain software that enables us to do so. Another question: if in your proceeding there will be a complaint where the complainant will be you, what are your actions in this case? Of course, I cannot consider complaint where I'm a complainant. This is totally impossible, and I think that there are no complaints that are still filed by me, active ones. So for 2 years but if there will be disciplinary complaint against the judge against whom you filed the complaint, it depends on the context of the case. I think in order for the third party not to have any doubts in my impartiality, I will have to take actions to self-recuse and to appoint this complaint to another rapporteur in order have no motives to cancel decisions on this complaint, in order not to start even smallest reason for doubt that conclusion. Tell us, in the unit where you were serving, they were part of the tenders. No. Those drones were not part of my unit. That would be totally in totally wrong practice. I followed that, and I took all measures dependent on me in order to not allow neither real nor potential conflict of interest. Within the last unit where I was serving, we were not using devices that we were manufacturing. When you were dismissed from military service, I was dismissed from military service in August 2024. What is your occupation now? Now I was on vacation after I was dismissed. I have to admit that I was totally exhausted and tired. And more than 1 year I was starting to work with software on modern biology, about dopamine on a study program about like dopamine system or other system, just to be able to take care of myself. Just I think this is very important. If we read any guidebook, any on time management, from one of the first points will be take care of yourself. My last question: are you now party in any criminal cases, and are there any decisions or rulings about access to your property? No, no, categorically no.
One easy question after all those questions. So you explained a lot about your motivation, which is strong, and your declared commitment, and also your deep understanding and sense of justice and fairness. And with all that, I would like to talk with you about your personal traits, personal qualities. So you've got a super high level of energy. We can feel in this room that you are like a boiling water, and it's like 120 degrees of Celsius. So my question is this: the role of the inspector, and I would say the daily work of inspector, would be, of course, participation in the proceedings, etc. But so much work, paperwork has to be done. Analyzing materials, writing drafting conclusions, etc., etc. So with this high level of energy, wouldn't you explode in this work? It's just, I feel that you have so much of energy to do a lot of things, but just to stay in one workplace, in the office for 3 days and just analyzing, reading and writing and then reading. I don't want to say that it's all about this capacity, but it is a lot of paperwork and analysis and this kind of. It's just this kind of question.
Дякую за комплімент. В першу чергу.
Thank you for the compliment. First of all, I'm used to paperwork. I call it legal thinking, like how you construct certain legal positions, how you put them on in written on papers. One of the courses that changed my mindset within Lawyer of Future program, we were taught how to draft document. Every lawyer thinks that he's the best in drafting documents. When I entered that course, I wasn't doubting that I'm the best in drafting documents, and then I understood that I know nothing about drafting them. We are never taught about that subject in higher legal institutions. We tend to difficult formulations in connection to based on we love bureaucracy language, but we can draft in a simple language. The US and British system, IRAC, issue, reason, conclusion, it's about drafting in a simple manner, and for me it's a professional challenge to be to work in the area.
Or some of this energy to this capacity. Okay.
Форма роботи дисциплінарного
The work of disciplinary inspector, of course, is about working with legal documents, and for me, I can mention analogy that successful participation of a lawyer in the court session is 5%. All other is legal considerations, preparing the case. This is 95% of the case. In order to be successful reporter, to speak on behalf of state in the court or you have to have exclusive competence and expertise in the matter. During the practical task, unfortunately, there was no communication on what Commission wanted to see from us from the situational task. I thought that for myself that those who will be checking us, I decided that they know law, they know practice, and that we should show our capability in our sentences, in arguments and reasons, and that's what I thought was required from us. And number two is legal documents that should follow from one legal document to the other. And in my opinion, disciplinary inspector should understand the essence of this process. What is the specifics of the criminal procedure? If we go back to the situational task, there was such quite important detail in the task. There was a questioning of an expert in Court of Appeal, because it's according to generally a Court of Appeal does not question experts, and it means that there was a ruling on the Court of Appeal about secondary court consideration of certain documents. It means that questioning of the specialist will be conducted according to the rules of first instance. Understanding this context, I think, will be immensely important in the work of the disciplinary inspector, for the person to have skills and expertise and competencies and experience in various proceedings.
Question, thank you.
Dobry den. Can you tell me whether you think every ethical violation should be grounds for disciplinary sanction?
Дякую за запитання. Ні.
No, not every. Every ethical violation should end up with disciplinary liability. In my opinion, it should be so much considerable that it will negatively affect how society views a certain representative of legal profession. For example, a judge was in a hurry to her work and crossed road on a traffic light, and of course it's ethical violation, but in my opinion this is not sufficient ethical violation to hold judge disciplinary liable. We are people and humans, and every human has a right for a mistake. We all had our mistakes, but only significant mistakes that undermine the trust in judiciary should be subject to disciplinary liability.
So undermining trust in the judiciary. The judge was in a rush to get to, I assume, the courthouse, and he crossed against the red light. Correct?
Дуже важливо.
It's important to understand the context. Like, we can model a lot of legal situations. Like, no, for example, today I didn't sleep well. Like, I was worried whether you received my explanations. Like, there were explosions at night, and I had little sleep. I woke up. I was a little bit frustrated. I have stress, and as a human, I can make certain mistake because of my internal condition was not up to that high. Yeah, for me personally, like, I'm not tolerant to situations of court rudeness when there is improper communication with the lawyers or with the prosecutors. But I understand that maybe there was an explosion in the morning, like the air raid, and there are issues with some close relatives, and this might affect as a stress reaction. This might affect a judge, yeah, and all this context should be taken in account, and not to hold liable a person when there is no 100% assuring that the disciplinary violation took place.
What if there's a pattern? In other words, it's not the judge goes against the red light once, but the judge goes against the red light half a dozen times, a dozen times. Is there an issue here about, one, respect for the law, and two, public perception, which is people are either going to see it or find out about it and think, oh, this judge who is supposed to apply the law thinks that he's above the law.
Дякую за приклад, він дійсно
Thank you for example. Quite an interesting case. I would love to work with this case if it was in my proceedings. Again, we talk about context. For example, if it's a crossroad where there is less traffic and there are like no other obstacles, and person just crosses this road like on autopilot. Person just used to walk like that. I think that we're not talking about this definitely disciplinary offense, but if a systematic marginal practice, like let's imagine our imaginal judge, yeah, which causes stop of vehicles. The drivers talk to the person and she talks back to the driver. We have to assess the whole context in order to take correct and weighted decision.
Did I hear you say you were involved with studying dopamine?
є в
In Kiev, there is a popular biologist, Petro Chernomorets, and he has like a popular course of biology, just like for common people, for work, and it is a very interesting course, and in some respect it has changed my thinking. He tells how the nervous system works, how like hormones work, how hormonal imbalance acts, how the serotonin system works, etc. And for me it was important because during very exhaustive military service I caught myself thinking that I have this signs of depression, and that is about serotonin system. And for me this training course was like really essential, and it was slowly, gradually moving me back to life. Thank you. So I'm advertising this training course now. I really recommend it.
Good afternoon. I will ask very quick questions now, and then I will reserve a few for the second part. The first one, please define ethical dilemma.
Не перепрошую, можете?
Please define what is ethical dilemma.
Етична дилема?
Ethical dilemma? Ethical dilemma is a complicated phenomenon within the framework of which we have conflicts inside the person of some specific ethical norms. For example, today I had a very difficult ethical dilemma today because my daughter has the 1st September today for the first time in her life, and and it's important for her and it's important for me, and I had a choice whether to go to her 1st of September or to take part in the interview, and I took the decision, and I will not have the possibility to go back in time and to see my daughter's 1st of September for the 1st grade. And the lawyer who takes decisions and is responsible for those decisions may have many ethical dilemmas like that.
In the family area, I will ask you another dilemma. Let's say you and your wife or brother or close relative, very close relative. Imagine someone. I don't know if your wife has driving license. I don't know the specific, but please imagine somebody very close to you who is driving and you are sitting next to him in the passenger's seat in the car. The person is under pressure for her or his ethical dilemma and needs to arrange something quickly for the next meeting. So she or he takes the phone and texts the person that I will be late or I will come, please don't close the interview and so on. You are there, and you are even saying you shouldn't do this while driving. Unfortunately, at that very moment, a pedestrian was hit by your car. No serious harm, but some, injury. The police comes, and they are going to inquire what was going on before the accident. Would you tell them that she was texting?
Of course, these are basic rules of attorney's ethics with respect to legality, that the attorney cannot advise any unlawful actions or the actions which contradict the law. And out of the context of integrity, basic integrity.
Question. My question was, the police will inquire.
Я зрозумів.
And
yes, I understand.
Or attorney, because you are not yet attorney, in that case, you are asked by the police what was going on in the car. And my question is whether you will tell the police or you will not tell the police that she was texting.
З позиції доброчесності.
From the perspective of integrity and transparency, if I have knowledge about the event, that is my duty to inform everything that I know about this event without hiding anything, without distorting anything. So, as it happened.
Very sophisticated answer, but I didn't ask what is your duty, but what you do.
Я буду вчиняти.
I will act with integrity. I will not do anything that can question my honesty and my position. So, I will not commit any unlawful actions in this situation.
Unlawful action, you couldn't be just quiet. Nobody knows she was texting.
Ви знаєте,
You know, the nature of lies is that sooner or later the lies become obvious. And if the police comes and there is a criminal proceeding, because we have a victim, and the victim will also provide explanations and testimonies, who was behind the wheel, who was on the passenger seat, what they were doing. That is called like input data for the traffic accident. It is necessary to provide all the information. So, after all, sooner or later, it is necessary to act as it is right to act.
And well, the police just ask, so what happened? And you would actively speak up against your wife or brother that I have to inform you, Mr. Policeman, that she was texting before the accident. Is this what you are saying?
Знову все.
Again, everything depends on the context. So there is a plan of investigation of traffic accidents. There is investigative group that comes to the traffic accident, the patrol police, and the first thing that they do is not questioning of the driver or witness. For the first time, they examine the location. They just, I think that in the interest of these persons is to do everything correctly, to record everything, who was moving where, with which speed, etc. Because if you inform some inaccurate information, you, as a potential witness in this criminal proceeding or any other proceeding, will be undermined. Because since the very beginning you did not act with integrity and honesty.
That's all for now.
So let's come to the second part. We will prolong a bit our interview because we have so many things to discuss.
Okay, Mr. Stanislav, lots of questions. Actually, quite many questions have already been answered by you. You've provided supporting documents with respect to your financial integrity, in particular you purchasing the house in Irpin, vehicle, cash funds. You've explained that. Based on your answers and documents, we see that they correspond to your declared income. At the same time, there are some other questions that we have to clarify with you, in particular with respect to I will try to phrase them as follows. Can you please tell me, when you were talking about fake mass media, media with integrity, etc., where would you put information disseminated with respect to you ties of the ex-mayor of Zaporizhia market, your partner without surname, Enterprise Center of Research of Unmanned Aerial Vehicles, and can this information harm you and in particular your reputation? No, no, it cannot harm my integrity. I've tried to provide this as inside information after attestation of prosecutors, that the prosecutor comes to the interview and there are different materials about this prosecutor in the mass media, some complaints, qualification disciplinary commission, general inspection, etc. And you try to make sense of all of these materials very quickly. And no, let's talk about you specifically. Can we please, I will finish this idea, just 2 sentences. Some fake news that they make some situations scandalous, and after all it turns out that this prosecutor is active, very fair, and he defends his position in the processes. And of course he has some people who do not like that, and they try to make him leave the process, to bring him to disciplinary responsibility, create problems for him. And after all there emerges the paradox that the prosecutor with respect to whom there are many posts, many news, but that is actually the foundation of the prosecutor's office. And on the contrary, if there is little information about the person and there was nothing to ask about during attestation interviews, but these people were not proactive. And with respect to these publications, some publications, they are all fake. They have no factual basis. I and my relatives have never been brought to any legal responsibility, and all actions were within the law. Thank you. Colleagues, do you have follow-up questions? Yes, if you allow. Mr. Stanislav, can you please tell me, taking into account your professional and maybe friendly relationships, can you specify the dates when you visited Azerbaijan and Armenia? I've never been to Azerbaijan, never in my life, never. Even though after the end of the full-scale invasion, I would really love to visit different countries. I visited Armenia before 2022. This was also about provision of legal aid under a very complicated case. That was the case considered by the Supreme Court. I'm absolutely convinced that this position was correct, and it does not influence my integrity or decency. I have to say that when I was mobilized, I suspended my attorney's license, I suspended my attorney's activities, and accordingly, in some active proceedings, I even sent messages and notifications that I was no longer the attorney, so that the court would accept my application in order to avoid any misunderstanding. And I also have to emphasize that it is unacceptable to equate the attorney with the client. That is the basic principle of attorney's ethics. Can you please specify the month in 2022? Before the full-scale invasion, I think it was the end of 2021, I think. Frankly speaking, this question was not asked in writing, but before the full-scale invasion for sure. Okay, I understand, thank you. Can you please tell me, how can you explain existence of 16 administrative reports on bringing you to administrative responsibility for the last 2 years? And where there are instances when you challenged these protocols in the court? I provided my explanations about that in writing. I was shocked by this as well. Yes, I understood that there were some reports, that is like a theory of small figures. You are very active in your work, you get this ruling, I pay for it, but when I saw the total number, I was very sad and shocked as well. That was absolutely incorrect on my side. I admit that it was not correct. I do not challenge such administrative protocols. When I was a young lawyer, I think I had this experience with challenging them twice, but it was not correct, and it was even before the creation of the patrol police. So basically, that's it about this. All the administrative protocols are paid. I do not allow them to move to the stage of enforcement proceedings, etc. I can explain the number. I've got myself thinking that a very active activity. I don't know, I'm going to Nova Poshta. I need to go to take drones to bring them to the airfield. Then I need to go to the forest. At some point, you just did not understand that. I never had any instances when I harmed anyone, that there was some other person who was affected by this. I do not drink alcohol at all, so like no Article 130s are there, and that is completely unethical in my opinion. And thank you, Mr. Stanislav. And my last question. Out of these reports that we know of, that is 2024, can you please tell me, as far as I understand, that was when you were serving in the military. Do you use your personal vehicle for that? And how is it related? Maybe the last event was after release from the service. It was within settlements, yes. Personal vehicles were allowed. No, it was not after your release from the service, because I asked you, well, you said in August, but the enforcement proceeding with respect to you was opened in May. So that was obviously before you were released from the military service. It's just not clear how you, as the service member, used your civilian vehicle. What was it? What were the trips? All actions which I committed were committed upon permission of respective heads. So, by the way, my colleague had a volunteer vehicle. We were using together for some time, but when we were driving in places where we were driving, it was completely damaged, and it was impossible to use it further. I can say that very active actions, lots of many active actions, and I visited those places where they do not use these vehicles a lot. But just because of trouble, you just fail to do something in time. Thank you. Colleagues, if you allow, let me continue asking questions in this block. Stanislav, we will not ask you questions that you've already answered with respect to your attorney's activities, because we understand that there is confidentiality and that you follow the rules of ethics, and at the same time you've provided answers. All of my colleagues have them. One more question that I have to you is whether you've complied with the principle of political neutrality. You've been asked this question as well. Can you please be concise? Yes, I fully comply with the criterion of political neutrality. There were questions about two political entities. Before the interview, I received replies from these entities that I'm not a member of these political parties, I'm not in their registers, etc. That's it from me. Thank you.
Do you still have an interest in this drone company?
Так.
Yes, I work there. I have this project-based work. which I'm doing there, I feel that that is my, devotion, that it's like for my soul. And yes, of course, in case of successful participation in the competition, I will comply with requirements regarding non-compatibility, and I will not be working anywhere on a paid basis. But it would be interesting for me to tell you about this work because I believe that it is really important. Thank you.
Stated that you would not continue your work on a paid basis. Would you still continue to work with the company?
If I understand to your question correctly, that in case I successfully pass this competition, then yes, of course, I will stop all other types of paid activities.
My question is, even if you're not paid, will you still be involved with the company? In other words, what I'm getting at is it going to take time to devote to this passion that you have?
Yes, that is my secret. That I didn't want to tell you about that, but you've asked. So I have this savior complex, a person who has who believes that he is not doing enough during the martial law period, and I would like to pro bono. During the free from work time, I would like to visit shooting ranges. I would like to collect drones. It is important for me, and that is important and meaningful for me. And by the way, I even know representatives of the judiciary who similarly have completed this training course of FPV and from Victor drones, and they also gather drones on their kitchen tables, and they have quite significant expertise in this.
Thank you very much.
Thank you.
For coming to the interview and for participation in the competition. So now you can say a few words if you would will to do so.
Заключні слова.
I'm so grateful to you. My deepest thanks to member of the foreign members of the commission to come to Ukraine during the martial law. You real friends of Ukraine. You do, yes. Now there are Ukrainians who are leaving country, but you are not afraid of anything. Thanks a lot. I think this competition already successfully happened successfully. I understood that when I arrived to the cognitive test, and I saw a lot of young men with their eyes shining bright. I see that people trust to public service and they are ready to work there. I think this is the biggest achievement of this competition. And in my final words, I want to ask members of the commission, as former director of FBI said to Mr. Comey, raise your eyes high to look at your decisions through the perspective of future. I think it's very important that after this competition, service will have people outside the system, those who didn't work in courts, who were not public officers. This will be important signal for Ukrainian society that young people, young lawyers, legal practitioners from private sector, that they will devote themselves to state when state is going through hardships. Yes, we are facing difficult time, and it's important to build up quality institutions. Glory to Ukraine.
And our decision will be made after this week when we will finish all the interviews. So thank you, good luck. Дякую. Доброго дня, пан Сергій. So today we have the last interview with one of the candidates for the position of disciplinary inspectors, Mr. Sergei Savchenko. So first of all, let me introduce our commission. We are today in its entire composition. I'm Reda Molyene, the chair of the commission, and we have members of the commission, Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Would you have any requests regarding the composition of the commission? Дякую. So we will have our interview for about 1 hour. We will be asking you some questions about your professional experience and background based on your profile, and also some questions regarding ethics and integrity. At the end of the interview, you will have a right to say some final words and remarks. And also, I would like to inform you that the interview is broadcasted, so if you have any information which falls under restrictions for its public disclosure according to the martial law, please inform the Commission accordingly and in the according parts of the interview, and we will make a decision on its holding it in the closed session parts of the interview. If there are no requests or questions so far, so we could start our interview. Добре. So I would like to ask you to start the interview with your short introduction and presenting us with your motivation and your understanding of the mission of this service. So up to 10 minutes. Thank you. The floor is yours.
Good day. I want to express my thanks to all members of the Commission on reforms being conducted in Ukraine and on dismissal, and thanks to the High Council of Justice for dismissal of certain judges of Dnipropetrovsk Oblast. I'm Savchenko, Sergei, and I'm started my legal activities in 1991. From the first time I didn't successfully entered Academy of Yaroslav the Wise, and then I came to the court, to our Pavlograd, in Pavlograd, and to the court chair, and he said that the competition is 18 people per seat. He took my phone, and in January 1992 he called me and said that there is a position for court executor. In a couple of days I was attending courses of improvement of professional skills. Then I was working as the court execution officers. There was a judge who was checking my execution procedures. Then I entered Kharkiv Legal Academy to the prosecutors faculty. 5 years I studied there and then I was assigned to Pavlograd prosecutor's office, where I was working as a prosecutor, and I worked there for 10 years. My professional duties were disciplinary and criminal cases against the law enforcement officers. This is what I was involved in for 10 years every day, and of course I had a quite extensive workload on considering cases, like from 100 to 200 every day, 5,000 refused cases like per year, and more than 100 cases that were forwarded to court. I was checking. I was supporting state prosecution. I was investigating cases from the scratch and was supporting state prosecution on them, especially with regards to law enforcement officers who committed criminal offenses.
My management noticed that my cases were going smoothly, so they gave me other criminal proceedings. Back then, these were called criminal cases. And I was investigating cases with respect to officials. These were directors of factories, chief accountants. There was even the court-appointed bankruptcy manager. Approximately, I had 24 cases like that. But I also had negative examples, and the criminal government was the notion that I faced not in 2013, but probably when Honhadze was murdered since 2000. And in 2007, I took a decision for myself to resign from the prosecutor's office. For 6 months, I was resting because there was very significant workload, and after working for 9 years, there was operational meeting. Our manager organized the meeting and said the discipline worsened, and we were like, everything was fine. And he was like, at midnight, Savchenko went home to sleep. And that was the environment in which I worked back then. After that, I was the entrepreneur in the sphere of law. In 2011, in January, I passed the exam to become the attorney, and I've worked as attorney since then until nowadays. I don't remember when I said goodbye to my entrepreneurial activities. It was before the war. I don't remember which year it was when I terminated my entrepreneurial activities. I tried checking that in my taxpayers account, but unfortunately I could not do that. Due to the expiration of 3 years, this information is also not available at the website. And unfortunately, I did not see your last email with a request to provide additional explanations from you. I've printed out some documents here in Kiev, so I can answer your questions orally. I understand which questions you're going to ask me, but I am happy that we have this opportunity. I would like to say that yes, really, every person could be in my place, could reach this stage. 2 exams. And if you have questions, I will even tell you that 2 exams for the disciplinary inspector is already honor. And I had one civil case which I could not resolve for years. And basically in a week in August they considered it quickly, very quickly. I submitted the claim, and a week later the decision came into force. Pleasant, but for that I had to pass 2 exams for the disciplinary inspector. With respect to my vision of this work, it's familiar for me. Being the attorney now, I've submitted 2 disciplinary complaints. One complaint resulted in the fact that Mr. Maselko sent a request 3 days later. If you are interested, I can tell you. The other one has been without the request. I have some thoughts. I can talk for hours about disciplinary responsibility of judges from the practical perspective. I have 6 children. My oldest son is, even if you suspend the broadcast, sir, I can't tell you where he is, but this is related to the defense of our country, and I'm really proud of my son. My older daughter entered the medical university this year. I'm also proud of her. My youngest son is 2 months old. I would like to share my skills, abilities, qualities, and I would like to invest them in this work regarding disciplinary proceedings or against judges. There might be an impression that I'm against judges, but no, I believe that there are two tasks faced by the High Council of Justice and the Service of Disciplinary Inspectors. The first task is to ensure independence of judges, so that a judge would not commit any disciplinary proceedings, and so this judge would be sure that there would be no pressure, that there would be no sanction against him based on some complaint, and that the judge can work independently, objectively, in line with other bungalow principles. But the judge on the other side should also know that if the judge commits the disciplinary offense, then there will be punishment, and that this judge will be brought to responsibility. Disciplinary responsibility is the duty before the employer to bear responsibility, to be responsible, and to be subject to sanction for the committed disciplinary offense. In this case, the judge has to bear responsibility before the state and the people of Ukraine. That's the responsibility of the disciplinary inspector. No possible deviation, only according to the law, either to protect against inaccurate complaints or protecting the person, legal entity, individual who has submitted the complaint, and bringing the judge to disciplinary responsibility.
Дякую. Thank you for your introduction, and now I would like to give the floor to Commission Member Pavel Zelinchik to start our session of questions.
Thank you very much, Mr. Savchenko. My first question is this. In your view, when the...
Sorry, I don't know English. I don't hear interpretation. I heard the first words only. No, 1 second, please. I only heard the first words.
Now we can? Now you can? So, please, if you can tell us when the Service of Disciplinary Inspectors starts operation in its full powers, what do you think will be the main difference compared to the current system when the disciplinary cases are being dealt with at the High Council of Justice?
A very good question. Thank you. I would like to point out that the Service of Disciplinary Inspectors has to preserve that level at which disciplinary service has been for the past 2 years, when rapporteurs are members of the High Council of Justice. I believe that your mission is to choose among candidates those people who will be acting like honorable members of the HCJ, like Maselko, other members of the HCJ, who will fulfill these duties at the appropriate level. And in this system, the rapporteur, in the current system, the rapporteur is the member of the High Council of Justice. He or she does not vote during the disciplinary chambers meeting. The HCJ member is only the rapporteur. And by the way, I would like to say, while I remember that, Once the service starts working comprehensively, it is necessary to resolve the issue about existence of vacant positions. 4 vacant positions, 2 from the attorneys and 2 from the president. And then we would have the comprehensive disciplinary chamber number 4, for example, in the HCJ. Because if you choose the service, these the rapporteurs will have more time to work, and they can consider more disciplinary complaints, and there should be the full composition of the High Council of Justice. And it can work, and 24 inspectors then can work, and then can provide sufficient workload for everyone. So therefore, with respect to the same functions, members of the High Council of Justice who are rapporteurs will perform these functions now, and then the rapporteur will be the inspector who will be a party to the proceeding, who can ask questions to a judge like why, and the judge can also ask a question why there are disciplinary signs of the disciplinary offense in the actions of the judge. The inspector has to answer to the judge why he or she believes like that, based on which materials the inspector has reached this conclusion that actions of the judge contain signs of the disciplinary offense. We have equality of the parties. If the disciplinary proceeding is open, then the party that is the inspector is sort of a quasi-prosecutor. If the disciplinary proceeding is open and the judge is the entity, the subject of the disciplinary proceeding, and the judge's representative is the defense party, according to the bank law principles, we have equality of the parties, we have equal rights, and the judge, the inspector, will have equal rights with respect to submission of evidence. But it's obvious that the inspector has a wide range of rights to request the case, to study it, to reach a conclusion, to prepare the opinion, to submit the opinion for consideration of the disciplinary chamber. At this stage of preparation of consideration of the complaint, the inspector has to resolve the issue. When he or she can return the complaint without consideration, or to submit the issue of return of this complaint for voting by the disciplinary chamber as set out by Article 106 of the Law on the Judiciary and Statutes of Judges.
My next question is a complex one. In your view, what are the most frequent, or it will be your choice which you will pick, most frequent or most dangerous or most serious ethical violations in the sphere of Ukrainian judiciary?
Corruption. In my opinion, corruption.
Specific what type of corruption? Because corruption has many faces.
All the manifestations that are set out by Article 106, receipt of unlawful benefit, for example, that's just very... one judge is caught. But unfortunately, this is a very prevalent phenomenon. This is my personal opinion. It does not mean that all of them are like that. Among new judges, for the past 10 years, most of them do not have this. These are manifestations of the judicial reform, and these are effective results. But unfortunately, those who have worked longer in the system, that's in my personal opinion. Since I was 17, I've been in the system. For example, another prevalent phenomenon, I've provided in explanations and I have it with me. I participated As a party to the case, I was a claimant, and the commercial bank was the respondent under that case. I won in the Court of Appeal. The Court of Appeal recognized that yes, really, the commercial bank violated my rights as the consumer. The bank accrued a penalty to me for the amount of half a million of hryvnias plus increased interest. 340,000 hryvnias were enforced as a result of the court decision. This court decision was drastically influencing life of my family, me. Only this year, I received the decision of the court that the enforcement letter was invalid, which another judge could not question.
Come to this case of yours later, so please save your thoughts for a later stage.
Yes, I've moved away from the topic. Another example. A judge of the cassation level failed to register the court decision in the Unified State Register of Court Decisions. I have it with me. I've provided that in the explanations as well, and I thought that maybe this decision would be registered, but this judge is still working in the Supreme Court. I checked today. 12 years. In my opinion, the disciplinary offense has been ongoing because the judge will soon reach the age of 65 and the judge will apply for retirement because the judge wants to have the lifetime pension, and you know the amount. 100 persons can get this pension, or one judge of the cassation instance. So that's the question. That's the second prevalent phenomenon, and I understand why it is done. As a Tony, I understand why, because there is a risk. I can assume that there was like extra proceeding, and then in this another case, he considered it very quickly in a month, and quashed the decision of the Court of Appeal. Maybe some extrajudicial communication. That is the second prevalent phenomenon among judges of our country, unfortunately.
Very much. I will just finish my note. And my third question is, from what you are describing, you are perceiving serious flaws. At the same time, I feel some kind of hope or positive evaluation over how the judicial reform in Ukraine proceeds. And my question is this. Please tell us how it is going on with the judicial reform, the best it can, or there are still obstacles to more profound changes in Ukrainian judiciary, and if there are such barriers or obstacles, what they are?
I believe that the judiciary reform is ongoing in the right way. And we need to have the court, we need to have not only codes like they are in Germany. I know that our judiciary system, they just took the code from Germany. For example, the administrative code, they translated it into Ukrainian, and we have the same investigative judges. All of those, all of that is good, but there are some shortcomings. For example, in Germany, the investigative judge has powers to oblige the prosecutor and investigator to resolve the issue with respect to suspicion, and we do not have that. The prosecutor does that. So therefore, it is possible to challenge the ruling on closure of the criminal proceeding for 12, 13 years. But to prove that this person was really the offender and that this person should be brought to criminal responsibility, the court does not have this power. This is a shortcoming. In 2013, this great CPC was adopted and respect to the system. But someone who is thoughtful and who was translating that and just crossed that out. Why? But I think that such honorable things, we see that there are some very positive events. Why not? I hope that this will go for the better. I'm not concerned about the judiciary reform in Ukraine. I see no significant obstacles for it. We've copied the legislation, procedural legislation, and in the past it was in line with the principles of the rule of law, but it was only formal. And now we really have leverages which the attorney, the party, can use and prove that they are right, and this way they can protect their violated right.
This is all from me in this part of the interview.
Thank you. So now I give the floor to colleagues, please.
Вітаю вас.
Greetings, Sergey. I will have next question to you. From your profile, when we analyzed it, you mentioned that you're practicing law from 2012. And what kind of cases these were? All types of cases, on all instances, economic, civil, criminal, administrative law cases. Administrative cases on administrative violations, offenses, first instance, instance of appeal, cassation. Please tell us how like in last year, recently, how many cases you participated in? I have a lot of time. I'm not about time. I'm about asking about cases. I spend a lot of time in court hearings, but the majority of them where I participate from the Center of Free Legal Aid. So if you will ask me about my income, no, I'm not asking about income. Yeah, but I haven't submitted those acts. Back in September, I had my account still under arrest, according to the execution letter that was staying in executive service by the commercial bank was submitting and returning it. So like I had to find the exact time when it was in executive service for it to be cancelled, because decision was cancelled back in 2016, and I have a lot of acts on my work that I performed for which I never received payment for. I'm not asking about payments, but I'm asking about the number of cases according to your attorney's practice. I didn't count, but every month, and in any case, at least I have 2 cases guaranteed. Yes, at least 2 cases per month guaranteed. Thank you for your answer. Did you filed any request to High Council of Justice or to High Justice Council with complaints? Yes, I already filed 2 complaints and I'm preparing 2 more complaints. I'm not a complainant, but I had no trust in to previous bodies. I tried to to file something, but they were returned. But now, when this composition for in the last 2 years is working, I was so surprised. So much respect. You all doing great job, and that's why just to finalize my answer. That's why before I considered this would be waste of my time, and without any benefit. But now I think it's indeed possible. I submitted, and in 3 days Maselko is sending a request. It never happened before. I was so surprised. In e-court system, the client says me, look here, yeah, there is a request already. This is something I couldn't imagine before. Just respect. If it's possible to say, please tell what was the reason for filing that disciplinary complaint. Yes, it will be pleasure. Judge of Kirichev District Council in Kirichevsky Oblast divided movable property of my client and claimed 3 million from my client, and he resides in Pavlograd. Why she violated principle of area of judicial responsibility? That's where the claimant is registered and her attorney. Surname is Luzik, yeah. So 3.5 million grivna, different oblasts. I think it's very obvious case. Do I tell about the second case? No, that's enough. Please tell us, from the statistics and from mass media, from social networks, maybe you know how many cases HCJ has under consideration. 10,000. In case of appointment as a disciplinary inspector, do you think if you will receive 500, 700 cases for consideration, how you will organize your work, how you will be able to optimize and to expedite and to improve quality of consideration of complaints? I will give a short fact of my biography. When I resigned from prosecutor's office, I was a senior assistant, and my functional duties were split into 3 assistants, and they added another 2 in 2 months. So I worked as 5 assistants. I had 10 years of working as 5 young assistants, and not take into consideration 24 criminal cases that I filed to court. Yes, I worked 24/7. Yes. I don't know whether it was right or wrong. Yes, for my first wife, of course, that was wrong. She didn't believe that husband is working always time and no money. Why you decided to resign from the prosecutor's office? I didn't want to participate in criminal offenses. I want, like, for example, I was investigating criminal case. I opened it on Sunday. Yes, because on Monday I will have court sessions. Like on Sunday, case Rachek, head of Ukrspetsjust. This is Pavlograd branch that was in charge of selling arrested property. He received a bribe. So this is how it was called. So he received a bribe in a form of arrested property, MAN truck, which is with a cost of 15,000 USD. I removed documents, conducted interrogations, collected all data, and then I'm summoning him for interrogation as a suspect. I was supposed to bring him note on the investigations, and he came for the interrogation on a white BMW, and criminal and case from the criminal department says he bought it in Pavlograd for 15,000 back, and the prosecutor's office was just opposite our building, and he could have left the car a little bit further, but he came intentionally with that car, and he says, "Shall we settle the issue?" I said, I said, have you been to my superior? And he said, "Go to Savchenko." And he said that your superior is the father-in-law of Shuba, and in a week passed, and a case is taken out from me. So that's only example of one case. Greetings, Mr. Sergey. Please tell us, in your opinion, what is your personal role in building up a new Service of Disciplinary Inspectors? How you see your role personally? Properly and with dignity to perform duties of disciplinary inspector. So I think at this position, and considering my experience, professional, and my knowledge, competencies, thank you. How you can explain such a low score at written test? I would like to ask you to be concise, briefly. I took as a basis the score 36.9. I took Mr. Kucher, and I compared what he said yes, and what he so when he said no, I said yes, and so so unfortunately yes, I said yes indeed, in addition, so I didn't, so I think that maybe because of that I lost some points. On the last question, fortunately I didn't now you're analyzing your written work. Yes, when I was analyzing it, yes. How can you explain this result? Not of the low grade. Yes, there are. I understood. You mentioned that you submitted disciplinary complaints, and you're preparing additional disciplinary complaints. Let's imagine situation that you are appointed to the position of disciplinary inspectors, and in your proceedings will be assigned a complaint where you are a complainant. What will be your actions? I will act in the same way as members of the High Council of Justice acted at disciplinary chambers when they would themselves file complaints, and then the complaint was assigned to them. I will announce self-recusal. Please tell us in your intro word, you can prevent submission of claims to the judges, or maybe I was wrong. No, how I can prevent somebody to file a complaint? So it's not. And also you mentioned that, if I understood you correctly, that after creating SDI, this service should settle the issue on filling the vacant positions of HCJ. I say that when the Service of Disciplinary Inspector will be working in full force, as I was asking the question, so that it is necessary for the High Council of Justice to decide the issue of having 4 disciplinary chambers, because there will be a lot of work for discipline and for disciplinary chambers, and there will be need in the fourth disciplinary chamber. And is it part of the competencies of High Council of Justice to fill up those vacant positions? 4 members of High Council of Justice, 4 seats are absent because the quota from the president is not filled in, and two places, and a quota from the lawyers. Yeah. I'm wondering why there is no communications with Mr. Usik, Yuri Ivanovich, with relevant persons in charge. I don't know, that should somehow, there should be some influence on the president, but something should be done. I understood, thank you. Good day, Sergey Anatolyevich. Let's go back to issues of your professional competencies. Please tell us, can disciplinary chamber return conclusions to the discipline inspectors, and on what reasons it can be returned? Yes, it can, but he can either agree and redraft conclusion, for example. Maybe it was not sufficiently motivated, maybe it was incomplete, maybe certain circumstances were not researched comprehensively, maybe judge provided certain evidences, materials that were not part of the conclusion. But if a disciplinary inspector does not agree, he can appeal a decision of disciplinary chamber to the High Council of Justice. Thank you. My next question: what legal circumstances of recusal of disciplinary complaint by the complainant, it will be still considered, even if he 10 times will recall it, independently on that, it will be still considered. I thank you for your answer. In your opinion, how open, like with media, with public sector, should be this service? Maximally, to the maximum, if it will be preserved as HCJ is working now, and if it will be remaining at the same level, that will be enough. For example, with pleasure, I am watching sessions of the disciplinary chamber. You can watch bloggers, and you can see how judges are changing. And I understand, it's not said as a joke, but when the judge already attended disciplinary chamber, and when they receive warning, I see how satisfied they are, because the judge could have expected different sanction, and until the end of his judicial life he will bear that experience with him. And this is prevention for all other judges. They will watch it, and yes, for this, wow, but I can be also a part of on the same place, and the style of judge changes immediately. I understood your answer. But we still try to improve, not to stay on the same level.
Regarding your application to different positions during years from 2020 to the prosecutor, then to the judge of the General Court of Appeal. So because now we learned about your motivation to become and to apply for the position of disciplinary inspectors. What is your motivation to try to apply with different positions? Thank you.
And as a judge of a court of appeal, my documents were returned immediately because I started to think, I need to act somehow, somewhere, work closer to Kiev, so to experience it. And there we are under rocket attacks. In my apartment was my children were witnesses to all these actions, and yes, unfortunately, that's so. And because the front line is closing to our city, that's I thought about, like, other places. And when if I were not applying to the judge of a court of appeal, I would physically not find out about this competition. And when I saw this competition, I forgot about that application. I was supposed to submit one document for discipline inspector in proper form. Other persons, they would add. I said no. This person for me. I saw that other people said for me the judge is for my character. I think this is for me, considering my experience. And with regards to the competition for the prosecutor, I totally passed. I passed through all tests. The practical test, I was there was 117 and out of 503 positions. Before I scored 33 points in cognitive test, and one now is 107. When I started passing those tests, I was not. I failed. I decided for me, I should be able to pass this test. So I was submitting to the competitions because I want to be. I also passed test into special anti-corruption prosecution. And I failed there, but now I get 107 point. For me, it's a perfect result.
Добрый день. In looking at your dossier, I see you worked for those 10 years at the prosecutor's office, and then you got your law license and started working there since 2011. What did you do during those 4 years between 2007 and 2011?
Look, in my presentation, I said that I was writing for half a year, literally. In my labor employment book, I was receiving assistance as an unemployed person for half a year, and then I was registered as private entrepreneur in the sphere of law, and then the legislation allowed that. I was going to civil administrative cases, and I had quite many of them. I published 11 articles in 3 newspapers, local newspapers, and I had quite a lot of clients. Back then there were such topics as regarding children, social payments, etc. So that was a wave of popularity. I worked there, and then some clients started asking me to protect them in criminal proceedings, and so under their pressure from my clients, who wanted this criminal protection, I took the exam. Back then there was no requirement to have a year of internship. I had sufficient experience from the prosecutor's office for that. So my break was for a few months. I was resting after the workload in the prosecutor's office over the 10 years before that.
Thank you. You stated that your familiarity with the process of disciplinary complaints is based upon your filing these 2 complaints and also your intent on filing 2 more. What type of investigations have you done in any of your roles? I know that as a prosecutor, there's a certain amount of investigation that gets done, but the police also give you a file. What type of investigations have you done?
Look, there was such a peculiarity. My main entities were employees of law enforcement bodies when I was working in the prosecutor's office. Back then, there was no internal security, no state bureau of investigations, nothing like that. There was in Pavlograd, there was only the prosecutor's assistant Savchenko, deputy prosecutor, and prosecutor, and that's it. Like 3 persons. Were covering the entire city. No investigators, nothing. We were doing everything on our own. Collection of materials, evaluation, initiation of the criminal case or disciplinary case, and questioning of the person, questioning of victims, recording, request of documents, and we were sending these materials. If actions of the person were the disciplinary offense, these materials were sent to the manager who was authorized to bring the person to responsibility, or we were sending materials to the court. And I was going to the court under my cases, which I initiated at first. I was preparing all the materials, all the procedural documents, and then I was going to the court as the prosecutor, and until the verdict was adopted. And all the cases referred to court by me resulted in no verdicts of acquittal. So those were all guilty verdicts.
Thank you. You referenced that you resigned from the prosecutor's office because you didn't want to be involved with corruption. And you referred to this case involving the judge.
The judge, not a judge. Sorry. That was not a judge. That was the head of Ukrspert's Justice Division, Radchik. I don't remember his full name, but it was like Ukrspert's used. That is the civil servant positions. That is the enforcement division regarding court decisions. That was like the part of the bailiff system in the Justice Division.
Clarification. Did you take any action with respect to his conduct or his misconduct?
Look, this process was governed by the Shuba, his crony, and that was Shuba Volodymyr Vasilyevich. He died already, but back then there were no reforms in Ukraine. And now there are institutions in the prosecutor's office where you have some respective like safeguards. There are bodies which consider these types of issues, but back then one of the elements was missing. One of the elements of legal state was missing. There was arbitrariness of that manager, of that head. He did whatever he wanted to do. And that was at the regional level. If the person had some funds, in my opinion, I understood that. If the person had funds, then he was allowed to do that. And all of the other cases were not reaching this requirement. I took this decision for myself that no, 10 years and that's it, goodbye.
Дякую.
We can start the second part of our
Thank you very much.
interview.
Mr. Savchenko, now we can return to the case you mentioned at the beginning when I stopped you that we will have time for that. From the information we received, it is quite clear the basic framework of the depth of the proceeding, and as you informed us, I suppose, if I'm mistaken, please correct me, but even the execution of the debt was terminated this year in August in a final kind of a decision.
Yes, it was closed. Yes.
So with regard to this proceeding, I have no further questions, but please, since you said at the beginning that you didn't receive our email on time with regard to our second round of questions we were asking, I would like to ask you now those questions, which is whether you received the income from your activities as an attorney or individual entrepreneur over the past 3 years. That was the first question. And the second question, that you declared that you earned about 90,000 hryvnias in all those 3 years, the same amount each year. And we asked whether there is any document which confirms that the taxes were paid from these amounts. Can you please provide us information about the type of income, and then the amounts, equal amounts each year, and the tax regime of those income? Thank you.
That is income from attorney's activities. I was not the individual entrepreneur back then. I have the general taxation system. The matter is that with respect to taxation, when I was registered as the attorney, there is such a form, such a certificate for OPP. That's the number of the form. And today, when I saw your email, I entered my taxpayer's account and I saw, I recollected that this form for OPP was registered in the 4th month of 2023. And when I started answering your questions about my commitments regarding taxation, I sent a request to my tax office for explanations, and we opened my taxpayer's account. We saw it there, and we clarified that one receipt passed and the second one did not pass for those years, unfortunately. And I honestly confirmed that yes, there is this debt. For 2023, I repaid the debt completely. In 2022, when the full-scale invasion started, I repaid debts which I had as of 2022, but when you had the first question to me, I realized that I had to send a request to the tax service, and I sent it to the tax office for those years. They called me and said that the document itself cannot be provided. So you can just see in the database which debt I have, tax debt which I had. And since the receipt was not downloaded, then yes, I really have this tax debt right now. But since my commitments were cancelled, I mean before the bank, I have certificates of performed works which have not been paid by the state regarding my activities. So I needed 1 more month, and then in a month I will not have this tax debt. Unfortunately, it happens that I have this tax debt. I do not deny this fact. But if I had more time, at least 1 month, I would have repaid it to the state budget. For a long period of time, my account was arrested. And in order to pay it, I needed to deposit funds to the bank account. But, you know, it would be proportionately. And I provided you when in 2022 they arrested my account. In 2024 they arrested my property, but now this arrest has been lifted. 1 more month and I will fully repay the tax debt. Unfortunately I have 6 children. Unfortunately I do not have this amount to repay it completely now. Unfortunately, yes, it is like that. It's a pity, but 1 more month I will submit my certificates for performed works, I will get money, and everything will be well.
Did I understand correctly during your first intervention that you brought with you some documents which would support your answers? So just if you agree, you can pass it to our staff when you will be leaving, but we don't need to go through them now if the commissioners agree. So for now, this is all. Sorry?
I would like to say there are documents that is about the closure of the enforcement proceeding where there is stated that the tax debt is 0. But there was a debt, and the enforcement proceeding was showed in the register of debtors because the court fee was not paid. That is also my mistake. I paid it. Everything is down there. And the debt here is stated 0.
Considering the time for now from me, this is all, and I would like to ask my fellow commissioners whether they have follow-up questions.
Yes, if you allow, I have 1 more question. Can you please tell us what is your attitude towards the ban on the Ukrainian Orthodox Church of the Moscow Patriarchate? Since 1998, I have no relation to the Moscow Patriarchate of the Church. I believe that that is my personal opinion. We have Ukrainian Orthodox Church and we have Ukrainian Orthodox Church of the Moscow Patriarchate. Since 1995, I've had no relation to Moscow Patriarchate. By the way, since you've asked this question, I'm included into those congregation of the Ukrainian Church abroad, and I was present at the meeting abroad, and I also have a picture there. I was at that meeting, and the American friend was there as well, the friend of the Ukrainian people, ambassador of the US, former ambassador of the US in Ukraine, John Harvest. And together with him, in 2008, I was there at that clergy meeting. So I think the testimonies of this person can be sufficient for you to show that I have no relation to Moscow Patriarchate. By the way, we were participants of this meeting so that we could create here the institution back in 2008, which would have no relation to the Moscow Patriarchate. And unfortunately, our government decided otherwise. They decided that, in my opinion, former persons who had direct relation and who were not hiding this, and they were saying, yes, we were in KGB. Everyone was in KGB, but not all. There were priests who were not in the KGB and who were not going to fulfill who were not serving that government. And by the way, it is prohibited by religious dogmas. And by the way, we have religious freedom, and if necessary, I can provide the picture. You can have it.
I absolutely agree, and I think that's the opinion of all Commission, that the religious belief is a constitutional right. And the question was definitely not asked by my colleague to question the constitutional right. Probably more, it was aimed to explore the, at least for me as a foreigner, very complex relation between the churches or patriarchats, especially in the view of the recent law of Ukraine, which provides some new insights into the regulation of these. But I think you answered, at least for me, you provided your answer. And if there are other questions, I encourage my colleagues to say now those questions. Okay.
So we can finalize our interview. I guess we already used our hour to discuss all the questions that were. So now you have 2 minutes for your final remarks, if you would like to say something.
I would like to express my gratitude to you for your work, again, for that level at which everything is happening. Thank you so much.
And we wish you a good luck, and the decision on the winners will be announced after 1 week, when we will finish all the interviews. So thank you for participation in the competition and in this interview. Good luck.